The following video is based upon true crime content. Therefore, it may contain images and/or language that some find disturbing. For this reason, viewer discretion is advised. Good morning, everyone. Welcome in. I've already got Blanco and Mark acting up in the chat, and Laura's not here yet because we're early. Bam is not here yet because we're early. Y'all better. Hey, Cass. Good morning, my love. Hey, Kara. Y'all better act up while you can because Laura's going to get here and she's going to get on to y'all. No, there's Miss Bama. Good morning, darling. I hope you're feeling better. And if you don't feel good today, don't worry about us. We're going to be fine. We don't have that many chatters that we have to be too strict in here. So it's not that big of a deal. Yes, this is day 4. Okay, so I came on a little bit early today because I wanted to start the intro to the case today because there might be some new people watching since it's Monday. And then I also thought we could watch some body cam stuff too beforehand. Your head's stuffy. Bless your heart. I hate that feeling. Good morning, Dread. All right, let's play this really quickly. This is the this is kind of like the intro to the case. And for anybody that's new to it, this will get you all caught up.
Community told Fox 13 she was house sitting for her neighbor who was away in the Florida Keys. Her neighbor's 17-year-old grandson, Collin Griffith, arrived on Saturday. And shortly before 3 p.m. on Sunday, his mother, 39-year-old Catherine Griffith, arrived and the two got into an altercation.
They were yelling at one another and he grabbed her and drug her in the house. And like I said, I don't know what happened on the inside. I really don't. I feel so sad for the mother. I mean, the grandmother. You know, she's a friend of mine.
A murder, a cold-blooded murder of a 39-year-old mother by her 17-year-old son. And it's not just a singular murder. But as we got into the investigation, we found that about a year and a half, maybe a year and 8 months, 9 months earlier, he murdered his father in Oklahoma. So let me tell you about this. It all started on September the 8th, which was this last Sunday, when we got a 911 call from Collin Griffith, who's 17 years of age. And here's what he said. He said he and his mother had a very long fight, and she fell on a knife and killed herself. And she's bleeding from the neck. He didn't say she killed herself, said he's bleeding from the neck. So our 911 operators appropriately were giving them instructions on how to do life-saving techniques. When the deputies arrived, he met the deputies outside, and he was calm, cool, collected, not upset, and he had blood on him. What we found inside was this knife. This knife is 12 inches long, and of the 12 inches, 8 inches of that is the blade. So he's saying that his mother fell on this knife. We started our investigation at that point. The next morning at the medical examiner's office and the autopsy, the medical examiner said it is not reasonable or plausible that she died the way that he said she did. Just didn't happen. There were witnesses outside the mobile home that actually saw Collin drag his mother into the house by the hair on her head. Collin is about 6 foot and 160 pounds. So an investigation started. This residence was at 77 Hewlett Drive, which is Auburndale, and it's called the Hamptons. It's a 55 and over community. And where it occurred was at Collin's grandmother's house. Collin's grandmother at the time was not there. She has another home in the Keys, and that's where she was. But let me go through some details, because as we start to peel back the layer of this onion, we find out that this is not just a singular event with Collin stabbing his mother in the neck and ultimately killing her. Here's what we found, and follow me as I read a timeline to you. On February 14th, 2023, on Valentine's Day, in Lincoln County, Oklahoma. There's a Lincoln County, Nebraska, too. In Lincoln County, Oklahoma, Collin said that his dad pulled a knife on him, and he shot and killed his dad. That's right. His father was named Charles. He shot him once in the chest and once in the head, and he claimed self-defense. The Lincoln County Sheriff's Office and the Oklahoma State Bureau of Investigations charged Collin with murder in the first degree. They dropped the charges less than a month later. They said they could not disprove Collin's assertion of self-defense. So he was released. Well, when he was released, in March of 23, just barely a month after the original murder of his father, he came to Charlotte County, Florida, to live with his mother. And when he came to live with his mother, Collin Griffith, who was 39, you would think things would be better. He would be really, really lucky that, hey, this was a self-defense and I'm here with mom. But 6 months later, guess what happened? He's Baker acted. So it's September, and as he's getting out of the original Baker Act, he makes a statement that, well, I'll kill myself, or I'll kill my mother by shooting or stabbing her. Charlotte County re-Baker Acts him the same exact day. They keep him 3 more days. Now we're 2 months later. This is November 2023. Collin then is arrested for domestic violence on his mother. And the reason he battered his mother is because she was disciplining him and took his video game privileges away. So he beat up his mother. He pushed her to the ground, and he stomped on her. The grandmother was there and witnessed this. Collin said it was self-defense. She made me do it. The grandmother said, no, no, no. Your mother did not provoke this at all. You simply were being disciplined and made to give up your game because of failure to carry out what you should, empty the garbage, wash the dishes, whatever they gave him to do. He claims self-defense when he stomped his mama, but he went to jail anyway. 3 months later, 12th of February in 2024, he has an argument with his mother, and he runs away from Charlotte County and comes back to Auburndale to his grandmother's house. Now, his grandmother's not there. And we got involved in this on the 12th of February, and the mother said, and the grandmother said, hey, we don't feel safe with him around, So our deputies who found him up here as a missing persons reported in Charlotte County turned him over to DCF. 2 days later, on the 14th of February, the anniversary of him killing his dad a year ago, he's reunited with his mother by DCF. Collin made the statement that I don't want to go home. I'll use any force necessary to avoid it, to include killing my mother. So that's the second time he threatened to kill his mother. 2 weeks later, so they didn't make him go home on the 14th, but about 2 weeks later, in March 2024, they reunite Collin with his mother again. Everybody's calmed down. Now, in May of 2024, Collin graduated from an alternative high school in Charlotte County and began attending community college. Now let's advance 4 months later to September the 6th. Collin has an argument about home chores, and he flees from his mother's house again and comes up to his grandmother's house. Grandmother's not there. She's in the Keys. So then mom lets the event calm down, and she tells her son, hey, you need to come home. And she asks him to come home and face his responsibility. Collin says, I'm not coming back home. That was September the 7th. So now we're to the fateful day on September 8th. Mom drives up here to Auburndale from Charlotte County. She arrives at 4 o'clock. At about 4:30, witnesses and neighbors see Collin and Mom arguing outside, and Collin grabs his mother by the hair and drags her into the house. Just about 2 hours later, that's when we receive a 911 call where Collin said, I've had a very, very long fight with Mom, and she fell on a knife and she's bleeding from the neck. Our investigation clearly and unequivocally shows that that circumstance did not occur like that. In fact, he used similar language to when he made the 911 call, 18 or 20 months earlier, when he shot and killed his father. It's important to understand, when you look at this, you see a kid. When I look at him, I see a psychopath. I see totally erratic behavior, to the point that he's already, at 17 years of age, shot and killed his father and got away with it, and stabbed his mother in the neck so hard that the knife went all the way through and was to the back of her neck, and she died there. He's being charged with first-degree murder, obviously, and we're asking the state attorney's office, it's their decision, but our state attorney's office is the greatest, to prosecute him as an adult. We've also wrapped back around with the prosecutors, the DA's office, as they call them in Oklahoma, and they said if we develop information during this investigation that allows them, they will reopen the murder investigation in Oklahoma and potentially charge him out there.
I'm Brian Haas, State Attorney for the 10th Judicial Circuit of Florida. The Polk County Grand Jury indicted Collin Griffith on the charge of first-degree murder for the killing of his mother in Auburndale last week. I made the decision to charge this 17-year-old as an adult based upon the egregious facts and circumstances of this case. Charging a minor as an adult is not a decision that I take lightly, but as state attorney, it is my responsibility to do so when warranted. There have been many questions regarding an incident from Oklahoma last year where Collin Griffith killed his father. While I have been informed that charges were not brought in that case, Polk County law enforcement continues to work with the authorities in Oklahoma to be sure they are provided all relevant information and evidence that will allow them to continue to evaluate their case as they deem necessary. The Polk County, Florida murder charge will now move on to an arraignment. My prosecutors and the deputies from the Polk County Sheriff's Office will continue to work together to pursue justice in this case and hold Collin Griffith accountable for his murder.
All right, there you have it. If you're new to the case, you just got caught up on everything. Hang on. I paused my YouTube Premium because I was trying to change my payment method and all that. And now I'm getting ads. So hang on. I might have to I'm going to have to re-add it back in before we get too started today. So we've got it up here. Once it starts, we'll be there. We won't miss anything. I do got an audio feed in there right now. Yeah, let's see. How are we doing this morning? Did y'all have a good weekend? I got up early this morning, obviously. Nobody was ready for me to be on this early. Mark got put in timeout already. See what happens when you're not here, Mark? We vote on things about you. We needed somebody to go in and clean the timeout room up. It was getting a little dirty. Let's see. So that's it on the case as far as being caught up. We've got about 7 minutes before they start or they're supposed to start. So I really don't have time to show you guys the body cam, but I did want to go. I do have it ready to revisit that on a break. We'll relook at the body cam. Here, everyone. Mark said, but I've been a member for 16 months. Nobody loves me after all these months. We do love you, or else we wouldn't give you so much attention. You're so spoiled. Anne. Hey, Anne. You've been watching replays this weekend? Oh, okay. So if you're trying to catch up, Wizard, go back and watch this morning's live from the very beginning. 15-minute catch-up speed. You could speed it up a little bit, and you'll know everything you need to know about the case. Was the sheriff the same one for Boone? No. That was Polk County, and Sarah was in Orange County, Florida. No, I can only imagine if Grady Judd was the same sheriff for Sarah Boone and what he would have gotten up and said about her. Can you imagine? What a great parody that would be. Got my comedy brain going this morning. By the way, she got moved to Lowell Correctional Facility, and I'm trying to do a little thing on that for y'all so that y'all can get caught up on, just kind of show you the facility itself and some of the news about the facility that's occurred in the past. It's probably the worst women's prison she could be in. Does that make y'all feel better? All right, let's catch up with the chat. Oh, do y'all want to catch up with what happened Friday? Friday afternoon was kind of dead. They were trying to make the mother seem really crazy and erratic, but I didn't see the mom. I didn't see Kathy Griffith, the mom. I mean, I know I didn't see the video itself, but I was listening in, and I didn't hear a mom that was crazy and erratic. I heard a mom who was frustrated with her son for his laziness and lack of respect for her and his responsibilities with being on probation and whatnot. So she was trying to, in essence, she was trying to keep him out of jail. But yeah, the defense was trying to paint that picture after they played the ring cam footage inside the home of the day that everything occurred. And you could hear Kathy just venting to her mother about everything and fussing at her mom because her mom had actually allowed Collin. Well, she thinks that her mother allowed Collin to go to her house. But I don't know if he just went and she didn't know or what. But I guess the grandmother liked to side with him a little bit too much, and the mom was getting sick of that. They did finally show that body cam to the jury, which we were like, yes. And we're going to watch that today at break just to revisit that because we haven't watched it in a couple of days. And Friday wasn't Granddad, was it? Yeah, Granddad came up on Friday. He said, Collin said a very harsh statement about wanting to unalive those bitches. Yes, that's exactly what Collin said about his mother and his grandmother. So for anyone in the chat, because I did see somebody saying, why didn't he just go live with his grandmother? She wouldn't have been safe either. Anybody telling this woman what to do, showing authority, or anybody showing this kid what to do and showing authority would have been in danger. Yeah, Grady Judd does love to talk. He's a little bit self-promotional, but sometimes he gets it right, I guess. Morning, Pope. Morning, Michelle. True crime junkie, Anja. Yeah, Anja said I heard a mother that was frustrated and at her wits' end.
Why is filing your taxes with Pre-Tax USA?
All right, I got to take these ads off. So hang on. I'll have to do that once court starts. They're not on stage yet, so don't worry.
Quality software, great.
I can't even click off of it. Especially your medicine ads. Oh, really? I know. I'm always fussing at people to have premium, and I do. Look at
Work
that.
today is broken.
Oh my gosh, another one. Is this what y'all get? Mark says payback for blocking me. You didn't get blocked, did you? You just got put in timeout. That's the difference. Buenos dias, Steven. I know. I need to just fix it and turn off put the other credit card on here. I was just trying to change some stuff around. I actually was trying to change the day of my premium, but I don't think it's going to work. Let me go into that and fix that now. So y'all won't have to see any more commercials. How frustrating is that, huh? Okay, I fixed it. Does anybody have YouTube TV? Did anybody ever get that? I'm getting so frustrated with all these different streams and trying to remember passwords and oh, thank you, Laura. I'm good though. Thank you though. It's just Hulu, Netflix. Let's see, we got Amazon, we got Paramount, Peacock, Apple. Who am I missing? All these paid subscriptions. And I told my sister the other day, I said, why are we paying for all this stuff? We don't watch it. We would be better off just renting something like a movie. If we want to watch a movie, we can just rent it when it comes out. And we end up spending less money.
Joey Wall.
And yeah, Stephen, all the prices going up and up and up. And it's like, after a while, you're like, remember when you originally cut the cord from cable and we all were like, yeah, we got the cable company. I'm saving so much money now because I did that. And now we're all back to paying what we were paying with cable. I think something's going to come along though and change it. I was just thinking about that the other day. I really do feel like there's going to be some kind of service that comes in, if there's not already, and kind of puts it all together in a package and makes it worth bundling everything and saving money. Pretty sure the day you start is the day it comes out. So just cancel and yes. Yeah, that's another one. I like Tubi and I like Roku. I like Pluto. I was watching some good movies on Pluto this weekend. Dredd, you're going to call yourself out. The cable TV people are going to come and arrest you. If we didn't have so many Amazon packages, my sister was like an Amazon addict. If we didn't have so much of that, I'd already have gotten rid of Prime. Mark said, read a book. What's a book? The only book I have is the Bible. Pretty much. I don't think I have another book in my home, to be honest. I used to have some great books. I used to have some, I used to collect antique books. And I had all of the Edgar Allan Poe stuff or something. I don't remember what I had. No, don't tell them that, Laura. No, they don't. No. We don't want that. Yes. Actually, Mr. Hendry will be making the argument.
We're in jail right now. Sorry, I was setting my computer under.
Let me make sure I got it turned up. I do. I got the volume all the way up. Can you guys hear it okay? Because it's kind of low. Look, they're talking about him, the state resting.
Your Honor, this time the defense moves for a judgment of acquittal on both counts. I will work with the kidnapping charge first. The state's charge of kidnapping. First, kidnapping is a specific intent crime, which means that at the time the alleged kidnapping took place, it had to be the intent to kidnap. And typically the intent is to commit something else. So it's charged right now that the intent was to either further the commission of another felony or to harm or terrorize the victim. Now, as far as the evidence that has been presented in this trial about the kidnapping, we have essentially the two neighbor witnesses who presented any testimony whatsoever about the kidnapping. Both witnesses describe Kathy Griffith as angry. They describe her as, stomping around in the yard, throwing things into a car. The first witness described her swinging her arms around a lot, both away from Collin and as she approached Collin, and even up until she was so close that Collin could reach out and touch her. So at that moment, we have the testimony, which seems to align between both witnesses, that Collin grabbed his mother. She exclaimed, according to witness 1, "Let go, you're hurting my hair." Witness 2 did not hear anything. And then, although it has been argued that Collin dragged her into the house, the actual testimony from the witnesses was that the two went into the house. So if we pause it right there, at this point, we have what is arguably a misdemeanor battery. We have what could be a defensible touch on Collin's part, that he, in response to his mother swinging his arms in his face, reached out and grabbed her. And whether or not he had the right to do so, either way, it would either be a defensible battery or a misdemeanor battery. When examined on cross-examination, neither witness said that they heard Kathy exclaim anything about not wanting to go into the house. They did not see her fighting to not go into the house. They saw her legs moving. They saw her go into the house with Collin. And that moment is what has been alleged and the only evidence that has been shown of a kidnapping. So at that point, Mr. Griffith's specific intent to kidnap has to have been completed. We do not have that in this case, Your Honor. We have not heard any evidence that there was any fight on Kathy's part, any unwillingness to go inside of that house in that moment. We know she didn't want to be touched at that time, that she said that you're hurting me. We don't know if she was upset about him having his hands on her. We do know that he was touching her too hard, essentially, is the evidence that has come forward. And again, that would be a misdemeanor, which would not be sufficient in any case to charge a kidnapping with. So we move on from there. What evidence have we heard in this case that is going to turn this from a misdemeanor battery to a kidnapping? Well, we ultimately have a deceased person in this house. We have, the fact that she is found in the house roughly an hour and 15 minutes after this incident occurred, with the yelling outside and the touch on the upper torso. And we have no evidence of what happened inside the house. We have no evidence that Kathy was not in that house, or was in that house against her will, that she remained in that house against her will, that she was not able to move in that house. The only evidence we have of anything that happened inside that house is the body itself, with the forensic evidence that has come into play from that, and Mr. Griffith's 911 call. Mr. Griffith's 911 call states that there was an extended, prolonged fight, and that they ultimately, there's the accident that she fell on the knife. There is no mention that that fight started outside of the house, that it continued inside of the house, that it continued all the way up until the moment of her death. There is no evidence that she was dragged immediately from the porch into the house and murdered at that time, like the state may offer as an alternative. We have not heard that from any witness. We have not seen that in any evidence that has been presented. So again, the evidence of the kidnapping turns back to the misdemeanor battery, that she was touched, that she exclaimed upon the touch, and that she continued into the house without doing anything else to say that she did not want to go in that house. All of the case law on kidnapping gets into whether or not that the crime itself was completed, whether it was necessary to complete the other crime if there is another crime that's charged. But all of it, every case, includes proof that the victim was held or moved against their will. And we don't have that in this case. So we are not even at the starting point of whether or not you should consider a phase-on test or anything like that that falls under the kidnapping line of cases, because we have not heard a single piece of evidence that says that Miss Griffith did not go inside of that house willingly. So for that reason, we are asking for a judgment of acquittal on the kidnapping charge. As far as the first-degree murder goes, Your Honor, the evidence that has been presented so far of premeditation is that Mr. Griffith had a conversation with his grandfather in which he said that he wants to kill his mother, that he wants to slit her throat, according to the witness. We have the testimony from the officers who stated that he said things like he wanted to kill her. We have the testimony of Mr. Griffith himself in the back of the car where he said that he could kill her. Again, other than Mr. Walantis's testimony, every one of those officers, every piece of body cam footage, every piece of car footage that we've seen is conditional. That if violence occurs, if she comes at me again, if anything, then premeditation does not override someone's right to self-defense. If it did, then every officer who ever acted with lethal force would be charged with a capital crime. They are trained to respond to situations, and they know how to respond to that situation. That knowledge does not create premeditation. The fact that Mr. Griffith thought about what he would do in a situation where he felt that he was being threatened, and even took it as far as to how he would do it, does not create premeditation. That is not a crime. That can still fall within the realm of self-defense. The only piece of evidence that we have that would go against that is that he didn't have enough marks on his body. I mean, the state offered physical proof that he had injuries. They have argued that those injuries were insufficient in opening. We have not had any witnesses testify to the extent of Collin's injuries, what could have caused those injuries, what could not have caused those injuries. In order for this to be a first-degree murder, we have to have premeditation, which so far I do not believe the state has proven, and we have to have a waiver of self-defense in some way. If there is just a waiver of self-defense, if this was a fight that got out of control, I apologize. Do you have to?
Just like John's school keeps calling up, I'm wondering if there's an emergency.
Yes, Your Honor. I understand.
The judge has a personal matter. His child's school keeps calling. Interesting. Wouldn't that be ironic if something... No, I'm not going to say that. That's mean. I'm not trying to be mean. I hope this judge doesn't go, you know what, you're right. I haven't heard him say either. That, it was, she didn't want to come in the house. He grabbed her by the hair and pulled her back in. She lost an earbud. There was blood on the outside stoop. And oh, by the way, when she got back in the house, she was unalived. I was trying to think of a better way to say that, but I can't. But it was an accident. Even though they were arguing, they were mad at one another. Everybody was heated in anger, and everybody was heated up. She fell on the weapon. He didn't do it. I think he's trying to get the kidnapping charges dismissed, which I could, okay, nice try, whatever. But is he still trying to get the other dismissed too?
Okay. Your Honor, I was speaking as to the, if this were a fight that got out of control and Mr. Griffith had started that fight, then this is arguably second-degree murder, as would be charged, that this was something that was created inside of the moment, that the decision to kill did not require adequate reflection, and that this would be a second-degree murder. So we have I don't believe that the felony murder should be considered, because I don't believe that the kidnapping is sufficient to reach that. And there's been no evidence that the kidnapping was a continuous crime. Again, we have proof of her injuries showing that there was some kind of fight. We have proof of Mr. Griffith's injuries showing that there was some kind of fight. We don't have any proof that Mr. Griffith made a previous decision to kill in this moment, that this was orchestrated in any way by him. In fact, we have the opposite. We have Miss Griffith showing up at that house without permission to do so, being angry as soon as she gets there and never cooling off, according to the witnesses. At the time that she gets into his face, Mr. Griffith acts. From that moment forward, they go inside the house and it's unclear what happened. We have no evidence. We have no forensic evidence that showed what happened inside of that house to show that this was something that was planned, that this was something that was thought out, and that this matched any kind of a decision that Mr. Griffith had made. If anything, it is more likely that this fight escalated once the parties got back inside. This fight escalated, that there was.
If you've got an old air conditioning or heating.
I apologize, you guys. Yeah, Laura, pull your stream up, please.
Air conditioning or heating system, and maybe you've been thinking of replacing it for a while, can't keep up with the
A second-degree murder and a battery. They have not had any proof in this crime that anything else would enhance this crime to a first-degree murder. This is a second-degree murder and a battery that happened beforehand. And it is arguably self-defense on either issue. But again, I will concede that by raising self-defense, we have created a circumstance where the jury has to make a finding of fact. So I'm not arguing that this entire incident can't be considered by them. I'm just arguing that it should not be a kidnapping and it should not be under the felony murder statute, and it should only be a second-degree murder.
I don't think it could be cast. Hang on, Cass. I'll answer that in a minute. It was directly said to Grandpa, though. That's what's not hearsay.
From witnesses we saw and we heard that the defendant grabbed Kathy by the hair. He did that forcefully. And what did he do? He dragged her / pulled her in against her will as she was protesting and yelling loud enough so that one of the witnesses could specifically hear from inside, looking out the window, stop, Collin, you're hurting me. At which point the defender dragged her / pulled her into the house, which was clearly forcibly, which was clearly against her will. And then once he had her inside, of course, he confined and/or abducted her from outside into inside and/or imprisoned her. The last place that she would want to be would be inside after being yanked inside by the hair by her son, who has told multiple people, obviously, his intention to kill her, when he's furious, when she had just sent him the text message regarding the other person that he murdered by shooting that person in the chest and in the head. And when she threatened to come forward and tell the officials in Oklahoma and elsewhere about the defendant confessing that it in fact was a murder, that it was not self-defense, and that he had planned it, the defendant's anger level was through the roof. So once he gets her inside, he has no prying eye inside. He had her by the hair, which there's no way she can get loose from that. So as he yanks her inside, once that door closes, that was clearly the beginning of the end for her. Now he's all alone with her, with no witnesses and nobody that could help her. And his intent was to inflict bodily harm upon his mom, or terrorize her, and or to commit or facilitate the commission of the murder. Judge, once the defendant gets her inside, there's not going to be an hour and 15 minutes of these two people talking and having a rational conversation. It was an absolute powder keg that went off immediately. So the defendant, as we come out to the first murder, you can see the pathway by which the defendant pulled her by her hair, dominated her physically. He's 6'2", well, weighs her by, who knows, maybe 30 pounds or so. He's bigger, he's stronger, he's younger. He had to go to the butcher block, take out the knife of his choosing, continue on with the premeditation, and then it's not just cut him, but stab her, one of the most vulnerable parts
in the human body, which was right in the neck. And as we heard from Robert wanted to do for so long, which was to stab her / slit her throat, watch her bleed, and watch the life drain from her. Which was to stab her / slit her throat, watch her bleed, and watch the life drain from her, which is exactly what he was able to accomplish with premeditation. So, Judge, I would rely upon the facts of the evidence and the whole record that went off immediately. So the defendant, as we come now to the first-degree murder, you can see the pathway by which the defendant pulled her by her hair, dominated her physically. He's 6'2", outweighs her by, who knows, maybe 30 pounds or so. He's bigger, he's stronger.
That Kathy was irate, that she was flailing around, and that he reached out, but that his demeanor did not rise. Like he didn't start, there was no evidence of rage or anything like that. So I know the state keeps using those words. That's an argument on their part, but that is not the fact that has been shown in this case. As far as the decision to choose a knife, again, that's not a fact in evidence. As far as the decision to dominate her physically, well, we have evidence of bruising. So I guess I would concede that there was a physical altercation, and it looks like Miss Griffith bore the worst of that. But I don't know that dominate physically is something that has been testified to in any way. Again, it's being argued by the state attorney. The size of Mr. Griffith that keeps coming in from the state's words, that he's 6'2", that he's some weight, we have that. We don't have any fact on Mr. Griffith's size. I mean, the jury has observations. They can see me standing next to him, and they can tell that he's much smaller than me. And I'll tell you, I'm not 6'2". So I don't think that that comes into play in a decision to, decide whether or not this was a premeditated murder. And as far as the kidnapping, again, the only evidence we have of Kathy's intent is when she shows up mad, when she's throwing things in his car. We have her intent. Yeah. And she had already gone into that house. I mean, she goes in, she comes out with stuff. That stuff was not sitting inside.
I'm going to pause it for just a second. Laura, I got it. It's okay. We'll figure it out on break. You guys, did you guys hear everything? Do you want me to back up? Because I can if you need me to. Right now we have my stream up, Laura, but you had muted us, so I'm trying to make sure everybody can hear the video. I need somebody, just let me know. We're good, Michelle? Okay. It wasn't that long? Okay. All right, I'm going back on then. And then we'll switch it over to Laura's on the pause.
So we have her not wanting to be pulled by the hair, but again, we don't have any proof that she was pulled by the hair. We have the autopsy of her body. We do not have a single shred of evidence that she was harmed in any way by a grasp to her hair. There's no bruising of her scalp. There's nothing like that that has been shown. So she said, "You're hurting me loudly enough to be heard." That's a battery. She did not say, "No, don't take me in there. I don't want to go in there. Stop." She was not dragged. I asked the witnesses specifically if her feet were going up the stairs, and they said yes, that she was moving her own legs, that she went into that house. So I understand the state's argument that they are making, but it is argument. They are not using the facts that have been shown. And the fact is that this is not a kidnapping. This is a misdemeanor battery and then a fight that happened inside, and that fight led to a death.
Taking the evidence in the light most favorable to the state, as I must, hearing on a motion for judgment of acquittal, I do find that the state has made a prima facie case as to each element of each offense, and the motion is denied.
Thank God.
Anything else we need to discuss before we bring the jury?
Judge, when do you usually do a jury instruction conference?
After everyone rests.
Okay.
Was there something in particular
No.
you wanted to address now?
No.
Are we ready for the jury?
I believe so.
I'm surprised. I really thought the judge was gonna seriously consider some things. He got crane-necked. He sure did, Mark. I mean, every defense attorney tries that, though. You know, that's just part of their job. Before they take over, before the state rests, they're going to go in and say, come on, drop the charges. And this is why. Bring the jury. Okay, we're going to try to switch over to Laura's. And there you go, Laura. Yeah. I'll keep mine up to... It might be a matter of me just refreshing my screen. Because I should not be getting commercials.
Call Susan Detman to the stand.
This way, man. Step right here, raise your right hand, just one by the
Susan, oh, this is Grandmama, y'all. I'm not even paying attention. This is Grandmama coming up to testify. Here we go.
Ms. Detman, will you please introduce yourself to the jury and spell both your first and last name?
Susan Detman. Susan is S-U-S-A-N, and Detman is D-E-T-H-M-A-N.
Ms. Detman, how are you related to Collin Griffith?
I'm his maternal grandmother.
So your daughter was Kathy Griffin?
Yes, ma'am.
Griffith, sorry.
Yes, ma'am.
Okay. So give the jury a little bit of an idea of who the other members of your family are. Who was Kathy's father?
Robert Willantis.
Were you married at some point to Robert Willantis?
Yes, we were married for 19 years.
When did you divorce?
We divorced in 1998.
After you divorced Robert Willantis, did you get remarried?
Yes, I did.
Who did you get remarried to?
Inaki Markovich.
Okay. And you might need to spell that last name for the court report.
M-A-R-K-E-V-I-T-C-H.
Ms. Detman, who are your children from your marriage to Robert Willantis?
John Paul Willantis, Kathy Willantis Griffith, and Christy Willantis Rooney.
Did you list them in ascending order of age, youngest to oldest?
The youngest to oldest.
Yeah. Okay. Do you have another child?
Yes, I do.
Who is that?
Kevin Markovich.
And that's from your marriage to Mr. Markovich?
Yes.
Now, Kathy, obviously Collin was Kathy's son. Did she have any other children?
Yes, she had an older son. He's still alive, Christopher Ray Griffith.
How old is he?
He is 24.
I want to ask you a few questions about Robert Willantis, your ex-husband. When you divorced in 1998, who got custody of your 3 children with him?
I did.
And since 1998, has Robert Willantis been a big part of your life?
No, except for the custody battles we went through.
What about, are you aware of his relationship with any of the 3 children that you had with him?
He didn't have a relationship once he was not granted custody of John Paul. He didn't want Kathy, considered Kathy to be damaged goods. He only sued for John Paul.
Okay, but what was his relationship like with his children after the divorce?
He didn't have a relationship at all until Kathy divorced and she reached out to her dad.
When did Kathy divorce her husband and the father of Collin and Christopher?
2019, if I remember correctly. It was like December of 2019 when they filed. And I think it took a couple months for the divorce to actually take place.
Okay. Now, we saw pictures of Robert Willantis on a trip with Kathy. Tell the jury about that trip, what you know about it.
So Kathy wanted to meet the biological Robert's mother, the biological grandmother, because Kathy had many medical problems. So she asked me, she said, Dad said he'll take me to California to meet his mom. They lived in Anaheim. The mom lived in Anaheim, California, but you'll have to pay for it. And I said, okay. I said, just please try not to do anything too expensive. And I'll see what points I can use for the hotels. And fly over there. You guys don't need to rent a car. You can use your dad's car if it can make it to California. If not, then we'll get a rental car.
So, Ms. Detman, did you in fact pay for Kathy to go on this trip with Robert Willantis?
Yes. I paid for all the food, all the hotels, Disneyland, all of that.
And when was that trip?
That was before she got Collin back.
So before 2023?
Yes.
After 2019, though?
And after COVID was over with.
Okay.
So I believe it was 2022.
Are you aware of any other trips like that that Robert took with his other 2 children?
No, he didn't really have communication with them.
All right. So I want to ask about Kathy's funeral or celebration of life. Did the family hold such a thing for Kathy?
Yes, we had a celebration of life right here at the funeral home in Lakeland.
Was she actually buried or was she cremated?
No, she was cremated. She had conveyed to me as well as to her sister and brothers that she never wanted to be put in the ground. She wanted to be cremated and later taken back to the ocean in Key Largo and her ashes be put at the Jesus statue that we have under the water in Key Largo.
Has that been done?
No, we're going to do that this summer.
Where are Kathy's ashes right now?
Right now, they're at Christy's house.
Was Robert Willantis invited to the celebration of life?
No, he was not.
Why not?
Robert tends to be very disruptive He has difficulty with truthful manners, and we just did not want to have more lies and destruction. The final time that we could say goodbye to Kathy.
I'm going to ask you some questions now that may also be difficult. In the last roughly 2 months before Kathy died, what personal medical things were you going through?
So in the last part of June, I was diagnosed with stage 3 colon cancer. I had to have part of my colon removed and an ostomy put in place.
After you were diagnosed and had your surgery, did you have a fight with Kathy over Robert Wolantis?
Yes, I did. Kathy was very adamant that she wanted Robert to take care of me, that I needed to pay for his flight from New Mexico to Lakeland, get a hotel for him for 2 weeks, and get some sort of a car, and even pay for his food. And I told Kathy, I said, that's ridiculous. He hates me. I don't want to be hurt by him. Plus, has lost his nursing license. I want a real nurse that has.
Okay, hold on.
I'm going to just object to all this collateral accusations.
Ms. Detman, as a result of you not wanting to follow Kathy's wishes as far as Robert Wolantis coming here and taking care of you, did that cause a break in communication between you and Kathy?
Yes, she refused to talk to me. She blocked my phone. She told me if I came over to the house, she would have me arrested for trespassing. She said, you can contact Collin, but you can't contact me.
And that, okay, I'll move on from this. Mr. Wolantis on the stand mentioned that Kathy got Collin a second phone, and that must have been what Collin used to talk with Mr. Wolantis on the phone every week or every other week. Tell the jury what you know about a second phone.
The second phone, I purchased a second phone when Collin came to live with me in the January, February time period, the first time she threw him out. And I couldn't leave a kid in the double wide by himself without a phone. Plus, since I didn't
Wait, hold on. Why didn't Collin have a phone with him when he went to live with you in January of 2024?
Because Collin and I were at the Mexican restaurant in Port Charlotte. Kathy and Collin and I were supposed to go. When I got there, Kathy said, no, I don't want to go. And I said, come on, at least have some nachos or something. No, I don't want to go. And I said, can I take Collin with me? Sure. So while we were at the Mexican restaurant, she called me and she said, don't bring Collin back. I never want to see you or Collin again.
And the phone that Collin had at that point, where was it?
It was at Kathy's house.
Okay, so you brought Collin to
the double wide in Arbondale, and I didn't even have internet because, of course, I wasn't there all the time. So if I needed to, I'd hotspot my computer. I didn't want an extra expense for internet or cable or any of that. And so I realized I couldn't leave Collin here without a phone. So I told him, I said, we're going to have to go to AT&T and get a phone for you. And I even got a 786 area code because that's the area code that I have in the keys.
And that second phone, did Collin have possession of it from January of 2024 all the way up until September of 2024?
No. He only had possession of it for that small amount of time from when he came to, which would have been, it was either the end of January or the beginning of February. He had possession of it there. And then when he left he took it, and I immediately got it by that weekend.
Okay, I'm actually going to show you what's been marked as defense exhibit number 16 and see if you recognize it.
I don't know if she is really reading from anything, guys. I think she's looking down when she's talking, but you can tell it's like she's trying to pull from her memory when she's speaking. So, yeah, it's very telling to the jury. Very scripted, very coached, which is horrible. Just get out there and tell the damn truth.
Look at that and see if you recognize those messages from January 2020.
Well,
What do you recognize those?
according to
No,
this,
don't
no.
read it. Do you recognize those messages
No.
between you and Kathy?
No.
Okay. Do you remember there being a period in January of 2024 where where Collin was with you for several weeks and Kathy didn't remember that he had gone with you?
Yes.
And do you know what was going on with Kathy at that time?
She was suicidal, taking pills. She just didn't want to have her life. She was drinking
Okay.
excessively. She drank Everclear as her alcohol of choice.
Okay, Ms. Detman, just answer the questions, okay? You mentioned that she was suicidal in January. I'm going to show you what's been marked as Defense Exhibit 15.
Defense is like, oh, this is horrible. Even the defense knows it's horrible. This is her yes, this is the mother speaking on her of her child. Can you believe this?
Recognize the subject matter of those texts.
Yes.
Judge would like to admit Defense Exhibit number 15 into evidence.
Objection?
No objection, Judge.
Received.
Ms. Detman, Defense Exhibit 16 dated February 5th of 2024, and the blue text at the top was Kathy's number 941-258-0963.
Yes.
And were you the number below that?
Yes, ma'am.
Okay. And you mentioned a 786 number, but you had two phones, correct?
Yes.
Why did you have two phones?
I used one for work and one for personal.
So the blue message on top talks about Kathy just having been released from the ER for an accidental overdose. Was that one of the times that she had a suicide attempt?
Yes.
So the phone that you bought for Colin in either January or February of 2024, and I'm sorry if you already answered this, but he didn't keep that after the brief period that he lived with you then, did he?
He went home with it and I had it back on the weekend.
Okay, so shortly after he went back home to Kathy.
Yes.
So Kathy, it sounds like off and on had estrangement from various family members.
Yes.
You mentioned that you and she didn't speak for quite some time after your cancer diagnosis. Had she cut other members of the family off at other times in her life?
Her and John Paul were not speaking.
Do you know why?
Yes. She got mad at his wife because the house wasn't clean to her standard. And she said, I'm going to call DHS, which in our state is Child Protective Services, that Isabella was not taken care of, that she was in danger, something. I know DHS ended coming up to John Melantis' house. Of course, the investigation proved that there wasn't a problem. And John just said, I will never have anything to do with her again. She crossed the line.
Any other family estrangements from Kathy besides you and her brother John?
So Kevin and Kathy were supposed to go to Washington, D.C. together.
Kevin is your son with
Yes, and Kevin
Inaki.
and Kathy were pretty close. They were supposed to go to Washington, D.C. together because Kevin was in officer basic training in Virginia for the Florida National Guard. He just graduated from college, and he had time off during the 4th of July. And Kathy said, you know, it'd be great if Colin and I could meet up with Jean Paul in Washington, D.C.
Do you mean Kevin or?
Kevin, I'm sorry, Kevin would meet up. I was supposed to go because, of course, my cancer, I couldn't.
Miss Volantis, I'm sorry. I know you're nervous, but the estrangement,
Yes.
how that
So what
occurred.
happened is Kathy contacted Kevin and said, unless you help me get your father arrested, meaning Inaki Markovich, I don't want you coming to Washington, D.C. with me.
Do you know what Kathy was referring to as far as helping her get your husband arrested?
Yes, they had an altercation in our farm in Arcadia during COVID. So it was during 2020, around Easter time. It was before Easter. She threatened him with a baseball bat, and she said she was going to get her gun and shoot him. And my husband brought a shotgun out and said, I have a shotgun here. We're not going to be doing this. And later she said that he used the shotgun, fired the shotgun. And I said, it was a double wide. I think I would know if a shotgun had been fired in the ceiling in a double wide.
So after that interaction between Kathy and Kevin, were they estranged from each other for a while? But it sounds like she would kind of change her mind about who she was close with or wanted to have communication with. Is that?
Yes, because she called Kevin the next day and said, I'm sorry, come on to Washington, D.C. with us. And Kevin said, I already told my cadre, my leave's been canceled.
Okay.
You can hear how frustrated the defense attorney is. You hear her just go.
Are you aware of threats that Kathy had made to commit suicide?
Yes.
How many are you aware of, if
I'm
you know?
aware of 5.
Okay.
No, 6.
I'm going to show you what's been marked as Defense Exhibit 14. See if you recognize this.
Yes, I do.
I'd like to admit Defense Exhibit 14 into evidence, please.
Objection
No objection, Judge.
will be received.
What is this exhibit?
I wasn't sure if Kathy showed that to me. I wasn't sure if it was blood or a magic marker because I didn't see it physically. She said that it had something to do with a song she was listening to. And she was upset because of the divorce.
And you can't quite see it now, but did you see a video of, so you can see the triangle for play. Had you seen the actual video of this?
Yes.
In it, can you see what's written on the left side of Kathy's arm? I mean, you can't see it right now, but do you remember what it said?
I don't remember what it said because it was just so horrific that that she was doing this to herself.
I'm coming up here so don't forget.
And if anybody slips up about the father's death, she's going to be the one to do it right here. Wouldn't that be? Ugh.
Have you actually called law enforcement on occasion when Kathy made suicidal statements to you?
Yes.
All right. So you said you know of about 6 threats. What about actual attempts by Kathy to kill herself? Or was that the 6 and I misunderstood?
Those were the 6 attempts.
Okay. Can you describe some of those for the jury?
Yes. So the first one was, well, she was still married and she was very upset and she had overdosed on her trazamine. And she told me, I was in Key Largo and she lived in Key Largo at the time. And I said, I'm going to have to take you in right now to emergency room. You're going to die. And she said, no, I'm not going in.
Ms. Detman, it's okay. You don't have to give all of those details. That's all right. I understand. So that was one attempt. What about other attempts that you're aware of?
So the second attempt was when she was in Port Charlotte. I had to go over the fence and open the sliding glass door. And she was in her bed, all dressed in black, and with a revolver in her hand.
And had she done anything with any medications that
Yes,
time?
she had overdosed on the oxycodone.
Did she end up going to the hospital that time?
Yes.
Any other attempts that you remember?
Yes. There was another attempt with oxycodone again, about 4 months later. Then there was an attempt with medication and Everclear. The second attempt, she went back to the emergency room and was admitted vapoactive. The third time, when I called Port Charlotte police, they got there and said, she appears fine to me. If she wants to drink in her own house, that there's nothing we can do. And then the most recent time was just in August of this year, August 21st. She called me and said she had overdosed on metoprolol, her heart and blood pressure medication, because the other ones didn't work. So she said, I did that. And I said, have Collin take you to the ER. No, I don't want to go. Have Collin take you. Finally, I talked Collin into taking her to the emergency room.
So, to your knowledge, Collin was home when she overdosed and actually had to drive her to the
Yes.
emergency room in August of 2024.
Yes.
You mentioned that Kathy had been Baker acted. Was that more than one time?
Yes.
The jury has heard a lot about some things that Kathy claimed that were maybe not true. How would you describe Kathy's reliability or her reputation for truthfulness?
Objection, Your Honor.
Judge, can we go sidebar?
A sidebar, really? You guys, this is awful. She's like, let me go over my notes while y'all are in their sidebar. Okay, I thought it was illegal for them to have notes. So I know we are saying that we think she does. It definitely looks like she's looking down to read notes, but is she just trying to recollect her memory by looking down and not looking up? This is so scripted and it's so not believable. Now, not to say that they're not going to take with what some of she says and go, okay, we can think about this or whatever. But honestly, it from the get-go, it's like grandma came out of the gate and was like, my daughter sucks. Boom, 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 boom. And if I'm on the jury, I'm like, wait a minute. This is too much all at once. Like, slow down, grandma. I know, Cass. I know. Isn't that what's sad? A victim they can bring up all the victim's past, everything she's done, but they can't talk about how this kid has already committed one crime before. He just hasn't been charged for it yet. Well, I'm sorry, I take that back. They can talk about it. They just can't say it was his guardian. It was his father. This whole trial is the craziest thing I've ever seen. I mean, well, it's just another level of crazy that I've ever seen on anything like this. Sweetie Pie says this is very disturbing. This is beyond disturbing. It's like true crime junkie. Exactly. She's just going way too far above and beyond. Hey, Mark, thank you so much for your super chat. That's what I think too, Patty. She's looking down and she's like trying to remember what she was like told, and this is karma to the defense attorney, in my opinion, because she's a horrible witness. Michelle says, no. I teach reading for a living. She is reading. Reading eye movement is distinct. Okay. Mark, while you were gone Friday, we all voted to put you in timeout as a joke when you first came on the stream this morning. So see what happens when you're not here. We do talk about you. We put you in timeout for. I told in my defense, I told Laura only 30 seconds, but she did it for a whole minute. So, I'm just saying that was her call. I let her do it. Yeah, this is so sad, you guys. I mean, if Kathy was having issues and stuff, I mean, somebody said it earlier in the chat. It's like, with a family like this, who wouldn't have issues? My gosh. And then somebody said they thought they saw the judge look over to see what she was reading. See, she doesn't even look up now. It's almost like she can't face anybody or anything. Usually witnesses will at least look up and around. She's not even doing that. And I just find that's really super strange. I know, Dred, you said it earlier. You said grandma's going to come in and she's going to tear down mom and defend Collin. It's absolutely sad. Mark put in the timeout this one. Let's see. She just wants her grandson. Oh. Yeah, they're in a sidebar right now, Gladys. I think grandma has a lot more money than mom does or did. So, grandma's looking good to grandson. Be a nice little pot for him because she's got a property in Key West and she's got a property there. She feels like crap for what she's doing, you guys, I think. Why is she acting this way? She's selling her soul to the devil and she knows it. You were watching one of Laura's videos while you were in timeout. That's not a very good timeout. That's like pleasurable. You're not supposed to have any fun in there. Defense attorney making her read, trying to keep her from mentioning him unaliving his father. If she's going to slip up, and this is when it's going to happen, you're absolutely right. Julie says, I think she's lost her daughter and now she's trying to keep her grandson, but I don't fancy her chances on cross when she hasn't gotten the answers rehearsed. Well said. Yeah, I hope we don't show any disrespect by joking around. Thank you for reminding us, Bama. It's just, I've never seen anything this insane but happen before in a trial. On this level, anyway.
Ms. Detman, I'm going to go through some individual things and ask you about them, okay? First, I'm going to approach with defense exhibit number 17 as it's been marked.
I think prosecution is going to bring up that video, that body cam they watched on Friday of her telling Collin he was lying. He better.
Just read it and see if you recognize it as being a text from Kathy to you.
Thank you, Michelle, for the super chat.
Yes, I do. I'd ask that defense exhibit number 17 be admitted into evidence.
Any objection?
No objection, Judge.
It is received.
In this text from June 27th of 2024, Kathy says that she was here and pressing charges, going to 77 Hewlett Drive. That's your address, correct?
That was the address in Auburndale.
Okay. to check on you and to pick up Inaki for charges of attempted murder and assault against you. Meaning she's claiming that Inaki actually tried to murder you, correct?
Yes.
Is that true?
No, he's never tried to murder me.
Just his mom and his dad.
So that's something that Kathy threatened and claimed that just simply wasn't true, right?
Exactly. Yes. Yes.
Has she done that on other occasions, make things up?
Yes. Yes. She made up that I was diagnosed with Lynch disease, which is it's an auto-recessive disorder where people have to have, they're more prone to cancer. So she said that her insurance company was forcing her to have a hysterectomy because of that. She also told Christy, and Christy was so distraught.
Okay, Ms. Detman, I'm
sorry.
sorry. No, it's okay. I understand. So she made up that you had a disease that you do not in fact have.
No, I verified with my oncologist that I didn't have.
She also made up that John Paul Volantis had been neglecting his child, right?
Yes.
Has she ever made anything up about Robert Volantis?
Yes.
What did she make up about Robert Volantis?
When she was younger, she said that Robert raped her.
And how do you know that that's not true?
It went to court. So I don't know. I only.
Did she ever tell you that she had made it up?
Oh, yes. Later, as an adult, she told me she had made that up.
Did she say why she made it up?
Yes, because she was mad at the situation between Robert and I.
Okay. Has she ever made anything up about her being responsible for everybody else's successes in the family?
Yes. She went as far to say that no one in the family would have any of their degrees, and that she, in fact, the only reason that I got my doctorate was because of her.
Okay. And did she actually make a threat to you regarding this
Yes,
belief
she
she
did.
had?
She said she was going to, when she was mad at me one time, she said she was going to contact the university where I work at. And I said, go right ahead. No, I had to.
What did she tell you she was going to
She said
say
she's
to
going
them?
to call the university, my dean, and tell him that she did all of my coursework and that I didn't do anything and that I was a phony.
Did she make up at any time that you're aware of that Collin was failing school?
Yes, she said that he had been failing school and that when he was staying at my house, that it was my fault because I wasn't observing him on the computer to make sure he was doing his work.
Was Collin ever failing to your knowledge?
No.
When did Collin graduate from high school?
He graduated last June.
Was that actually ahead of schedule?
Yes, that was a year ahead of schedule.
And did he, in addition to graduating early, did he ever, did he get college credit?
Yes.
At the same time?
He was dually enrolled in college.
You mentioned earlier that you had paid for some trips, the trip for Kathy to go visit Robert Volantis and meet his mother.
Mm-hmm.
Did you pay for other trips for Kathy?
Yes, the cruises that they went on, I paid for.
And the other trips that the jury has seen pictures of Kathy and Collin, who paid for all of those trips?
I did.
Did you also have, you mentioned points and using points for things.
That's our DVC, our Disney Vacation Club, as well as I have points through Hilton Honors.
Have you ever witnessed Kathy not being able to control her temper?
Yes.
Can you describe some of those
Yes.
times?
She went at.
Your Honor, if we may approach for a moment.
The headset that Mr. Griffith is using is on mute somehow. I can't figure out how to unmute it.
Headset.
It doesn't appear to have any buttons on it at all, but I may not just know how it works. It indicates that it's on mute. It has like a little, that's the one I've been using.
Poor Collin can't hear his own trial. He needs a headset? Why does he need a headset? We can hear fine. Why can't he? I'm confused. Headset is for sidebar. Oh, thank you, Michelle. I forgot about that. He has to have the headset so he can hear what they're saying in the sidebar. Okay, gotcha. I forgot about that. Thank you for reminding me. Oh, you guys, this is awful. It's so scripted. Surely clearly, Mark wants its headset for the timeout room. We'll think about that. I already put a slot machine in there for you. Michelle says she knows more about Florida courts and law and zero about Australia, where she's from. You know, that's funny because you watch so much of the trials over here. Yes, Gladys says it's the defendant's constitutional right to hear all discussions. Don't call you Shirley. Clearly. So Grandma is on Collin's side. Hey, Shelly. You know what, Shelly? I got to pull up your pictures because I'd forgotten about them, and I was going to show them today when we were on break. They're so big. Let's see if I can open the email up. There we go. So I've got them pulled up, so we'll look at them on break, Shelly. Everything is sealed and confidential in Australia. You know, I always kind of wondered about that. Like, I do think that we are here in the United States, we're allowed to say a little bit too much before the trial starts. But you can't stop people from giving their opinion on things. But I think that when the prosecution feeds the public with different, and I'm not saying they do it, well, I don't know, maybe they do it on purpose, but usually they have to say, this is why we arrested somebody. This is part of the evidence that we found. And it can be misconstrued. It can be taken, over the top by people that talk about things and stuff. But I just thought that, I don't know, I feel like sometimes we know a little bit too much about the trial going into it, and that they should have more, like we were talking about the other day with the Idaho 4. We don't know a ton about that trial because they've kept it so under wraps. Everything is sealed in it. And I just feel like that's probably the way it should be. At the same time, though, we know more about what the defense or what the prosecution has with all of the media and everything circling it. So it's kind of but we just, as far as court goes, it's kind of,
Members of the jury, I'm going to ask that you step into the jury room for just a few moments while I discuss a matter with the lawyers. We'll be with you soon.
All rise, please.
Hey, JPC. So you're going to get to, I guess, hear what they're saying because they want to put it on the record. I don't know. Defense saying because his mother was a wacko, it's okay that she's unalived by her grandson, by her son, and that it's okay because she's a crazy too. Yeah, basically, yeah. Because Grandma said that at 6 different times. I wonder if the defense is going to come up and ask about what Grandma did to try to help her daughter when she was having all these self-harm delusions and whatnot. I would ask that. What else would you ask if you were on the defense, you guys? To throw Gma off. We got to throw Grandma off. Prosecution has objected several times. I'm very thankful for that. So they're saying her dad wasn't in her. That's, that kind of washes everything out. If the dad wasn't around, no wonder the child's, having mental health problems. She's probably depressed. They spend half their time in the jury room. Oh, yeah. Bless their hearts. They do, don't they? Shelley said she has been interested in the Memphis 3 trial. Have you watched all the documentaries on that? There's a ton of documentaries on that one. That would be a good one to just come in and talk about one night. There's so much surrounding that trial that's, you kind of wonder if they got it right or not. What, he's reading something. Is he reading the witness? Is he reading the witness's notes? She's a defense witness, JPC. Yeah. The grandmother is testifying against her daughter for her grandson. Okay, now they muted us.
There's two separate things here, specific instances and reputation. Specific instances need to be known to the defendant as far as I read the instructions. As for reputation, there are 2 instructions, one when the reputation is known and one when it's not, but it's offered to prove that the alleged victim acted in conformity with that reputation, which is, I need you to talk me through how you're doing that, or are you not using that?
No, I think it is relevant because the defense is that Kathy grabbed the knife in the house in Auburndale, and that fits with past instances where she pulled a gun on Collin, where she attacked Inaki with a baseball bat and said she was going to get a gun, where she pinned her then husband against the house with a car, that she stabbed her husband and burned him, and those were in front of Collin, and she has independent knowledge of those too. So those are the specific instances.
Yeah, but he was abusive.
Judge, I have nothing further to elaborate on besides my objection in the hallway
and I object to anything that will be contrary to what Your Honor just read in the jury instructions, Your Honor. It might be I don't know, it might be a question by question journey to see what, if anything, is admissible or relevant based upon the application of the question asked by Ms. Thornhill, the jury instruction differentiating between, as Your Honor pointed out, the reputation or things that the defendant has to have been present for, have personal knowledge of, and Ms. Detman, depending on how narrow, or maybe I should say how wide her answers are going to be.
As far as her reputation, it's my understanding that her reputation within the family was for being dangerous and violent, and people were scared of what she might do at any given moment. So I was going to ask about both.
While I understand the community for purposes of this type of reputation evidence may be narrower, you're still going to need to lay that predicate.
Sure.
This is a family of estrangement, after all, it seems, so.
Because of her violence.
Well,
yeah.
But I don't know who's estranged from who else, so.
Well, and it,
You know, she needs to understand and know that family community.
okay.
So,
And even if somebody's not still a part of that community on this particular day, I mean, they don't.
I'm not suggesting it has to be at some particular instant in time, but I haven't heard a lot about her closeness with others who may share that in that reputation or have knowledge of that reputation.
Okay. I will do my best.
And we'll just take it question by question as Mr. Levine suggests.
Okay.
Do you want to go ahead and just take our mid-morning recess?
That's what I was going to ask, if I could.
Mr. Levine?
Yeah, that's fine, Judge.
All right, we'll take 10 minutes.
Sorry, everyone. I was getting a coffee refill. What happened? Are we on a break? Well, at least you could say something about this trial. It's definitely interesting.
A lot of times,
Joe, whoa.
he needs like a shock. Good.
On break. Okay, thank you. I know I needed to go do some laundry, and I was going to listen while I work, but I was like, I'm afraid I'll miss something. Okay, so thank you. I missed that. Quarters on break, 10 minutes. So what do we got? We've got Grandmama coming up saying that Dad's wasn't in Kathy's life early on, and he's a loser. And then she comes in and says that Kathy self-harmed 6 attempts, and she's a horrible person. Just over and over and over again. Just I didn't even make notes on Grandma. I just put awful, unbelievable, coached, rehearsed, sad. It goes beyond somebody getting up there and saying, I'm the grandmother. I'm in a tough situation. But she's trying so hard to make her daughter look horrible. Yeah, the grandmother wants him out. Hey, Hubgrass. She may want him out, but if he comes to, well, he won't come to live with, well, he might. No, he won't. He won't come to live with her. He's going to have money from everybody's estates who he's unalived. I wish the defense, I wish they could bring that in. You guys, if this Oklahoma trial happens after this, I cannot wait. Because I want to know how much money he got after his dad died. So I almost wonder, affluence teen. Anne says, I just have a feeling mom's going to slip up. You know what? That's true. The prosecution might get her in a slip up. The prosecution has kind of been, in our opinion, over the last several days, we've been a little unimpressed with the prosecution. Poor one guy's up there by himself. I feel bad for him that he's up there by himself. He's probably got tons of trials that he has to deal with in addition to this one. And this was a speedy trial, so he hasn't had as much time to prepare for it. But there's just times I want to say, wake up, object, do this, do that, do something. This can't be right. I did not watch the Carly Gregg trial, and that was here in Mississippi too, right next door. So I wish I had. I almost want to go back and look at that one. Tony, you got to go to work. Well, thanks for stopping in, Tony. True Crime Junkie says, how do we know that she really stated that she lied as a child about her father's abuse? There is no evidence to say she did, and a lot of perps walk. Yeah, there's not a whole lot of anything, is there? All we have is hearsay. Isn't some of what Grandma's saying here hearsay? Gabrielle says this trial is ridiculous. Is it Gabrielle or Gabriel? This trial is ridiculous. Nobody speaks for the victim, not even her own mother. My son has mental issues, bipolar. It makes me even more protective of him. But then somebody earlier in the chat said she's lost her daughter, so now she's trying to save her grandson. Is that what it is? Yes, Shelley, the prosecutor better come back with something good. This is his time to shine. Tony wants to know where this is taking place. It's in Florida, in southern. Well, it's in the middle of Florida. It's Polk County. It's near. What is it? North of? Yeah, it's north of Orlando. I know y'all say she's reading, but I thought that you couldn't have, because I heard one time that police officers can't read from their report. They can only review their report from memory, to help them remember something, put the report down, and then answer a question. That's why I'm kind of like, wow, if she is reading something. Ooh, they are really having some issues with the audio in that courtroom this morning.
Is it okay for me to be back in here, or should I go? It's fine as long as.
Are y'all still discussing this stuff?
Yeah. But she's still on the stand. We can't really talk.
Yeah, True Crime Junkie. You know what? Yeah, Kranick did protect George, didn't he? More so than this judge hasn't done anything to protect the witness, the victim. Prissy, that's a good, yeah, very good. That should be a question the prosecutor asks. Would you feel safe if Collin comes to stay with you? She's going to say yes. But does she really believe that? Oh, yeah. In fact, I had made a note about that, Shelley. Megan Boswell, that case, it's about a baby, and I don't like to do cases with babies. But yeah, her jury selection starts today. And then we also have Corey Richens has a hearing today. We're supposed to hear from the judge about his decision on their last motions they went over. So there's a good bit for us to look at during, I think there is, during break, lunch break. Laura and I were talking on the phone this weekend, and we were going over all the upcoming trials. The Swan Boat Club has a hearing next Monday, and then we have Robert Cremo III, the 4th of July attacker over in Illinois. He has a hearing on Thursday. And then you got Lori Daybell's trial starts on the 24th, is what I have in here. I don't know if that's true or not. And then the 4th of July attacker's trial also starts on the 24th. But, I say starts. That's jury selection. And we were looking into March for it seems like there's a lot of trials happening in October this year. Big trials. We were just kind of trying to prep for what's coming up. If you guys have any ideas of trials coming up, anything we should go over, please let me know. I'm going to mute the court audio. It's annoying. I know. I don't like to do baby trials. There's so many of you guys that feel the same way. I probably shouldn't even look at it, huh? Ann says, seems like the judge is ready to retire and doesn't care, going through the motions. Ooh. I wouldn't either, sweetie pie. I would not either. Can you imagine anybody who would want to have this person in their home after he's done this to his father, then his mom? Patty's wondering about the older brother. I think that today we're going to hear from all of her siblings, the mom's siblings. But I'm really hoping too that we get the older son, Collin's brother, also speaks. I was kind of hoping that he was going to testify on the prosecution side, but I guess not. I mean, when it comes down to facts on facts, though, if you think about it, so Collin did what he did. And if you say, well, he did what he did because of this, 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 and this, it wasn't that doesn't really, and by law, it doesn't really matter. Because what matters is the fact that it wasn't self-defense. You can't call it self-defense. So you can't just say, well, I had a crappy mom, so I unalived her. Okay, so that's okay. Yeah, you're good. You're good. We'll let you go now. And it seems like that's what the defense is doing here. Yeah, his childhood sucked, or yeah, this or that happened, or, everybody has problems, but you can't, that doesn't give you the right to unalive someone. I feel like we're just getting very pulled away from the whole point of why he's on trial here. We're so busy victim blaming that we're pulling the jury's minds out of the thoughts of, and maybe not, maybe the jury's on point. I hope they are. Hub, can you imagine? What are they going to say about me when I'm gone? It's just so sad. It's so sad that the only voice that this woman has is the prosecution right now and her father. And even if the father wasn't in her life as when she was younger, maybe he's trying to make up for all the bad he did by getting up and speaking for her. Maybe he's realizing that nobody else is going to get up and speak for her. You can be your family's worst pain in the neck to deal with. You could be the worst one in the family. But if something happens to you, you would want your family to stand up and speak out for you. That is not happening here.
We're back on the record. Defendant is present with both lawyers. State counsel is present. We're ready for the jury.
Yes, sir.
All right.
We don't know for sure if they have, but we think they will reopen the Oklahoma case for the father's death.
All rise, please.
You talking about Collin laughing, Myron? Isn't that ridiculous?
Please be seated.
Ms. Detman, I'm going to ask you about some specific instances and may ask you to describe a little bit about them. So starting with, are you aware of Kathy having pinned her then husband to the wall of the house with her running car?
Yes, ma'am, I know.
Okay. And were you present for that?
No.
Have you ever, are you aware if Collin was aware of that incident?
Yes.
He was aware.
Yes.
What about an incident where Kathy stabbed her then husband with a corkscrew and then burned him with a terrarium light? Are you aware of that incident?
Yes, ma'am.
And are you aware that Collin was present for that incident?
Yes, ma'am.
Are you aware of Kathy threatening to kill her then ex-husband's girlfriend's family in Homestead?
Yes, I am.
Are you aware that she actually started driving toward their house to follow through on her plan?
Yes.
Did you actually speak with her on the phone then?
Yes. I was telling her that what she was doing
was crazy. She was going to get in trouble, that she couldn't take it out on 3 innocent lives in Homestead. She needed to turn around and go back home.
Are you aware if Collin was aware of that incident?
I'm not aware.
The incident where you said Kathy attacked your husband with a baseball bat.
Yes.
Are you aware if Collin was aware of that incident?
I'm not aware of that.
And have you ever personally witnessed Kathy engage in a physical act of violence towards Collin?
I know that there was a fight at the house in Port Charlotte, and the fight started because she was beating him with a belt and making him do push-ups, sit-ups, push-ups, and then holding a weight above his head while he was running in place.
Okay. When you say that she beat him with a belt, were you actually there for
Yes,
that?
I was, and I tried to stop it.
Right. What about, are you aware that Kathy pulled a gun on Collin?
Yes, and then later she said that originally she denied it, then she said yes. She pulled out the gun and handed it to Collin and said, just kill me, shoot me.
So she actually admitted that
Yes.
to you.
Yes.
And obviously Collin was aware of that because he was the one who was present with her.
Yes, and Corporal Rendas was aware of that also.
How was Corporal Rentas aware of this?
Because he and I and Kathy were talking about that. There's a difference when you take a gun out and give it to somebody and say, here, kill me with this, versus somebody pulling a gun out and putting it to their head or to their chest.
And so Corporal Rentas was a part of this conversation where Kathy admitted she pulled a gun.
Yes.
And she said she handed it to Collin.
Yes.
Did she ever admit that she actually threatened to kill Collin with it?
No, she never did.
Within your family, you've talked about some of the family members. Despite some of the estrangements that Kathy had, would the family sort of maybe not talk to her for a while and then everybody would come back together, take trips together? I mean,
I was the constant in her life. My oldest daughter didn't talk with her while she was married.
okay, what I'm asking about is, did the family talk about Kathy with each other?
Yes.
Okay. And whether or not Kathy was estranged from anyone at any one particular moment, did the family continue to have discussions about Kathy?
Yes.
And was there, did Kathy have a reputation within your family as being violent?
Yes.
Did she have a reputation as being unpredictable
Yes.
and volatile?
Yes.
Despite all of this, did you still love Kathy?
Yes, very much, very much. I always wanted to help her.
Yes, we can tell, grandmother.
It appears that Kathy at times wanted Collin with her at all costs, and then at other times wanted nothing to do with him.
Yes, when she had Collin back for about a month, she spoke with me and she said, Mom, I have to get up every morning at 6 o'clock, take him to school, and then I have to go back and pick him up. And I said, you don't have to, let him ride the bus.
Okay. I'm going to show you what's been marked as Defense Exhibit 26 for identification.
What number is that?
26. Will you read this and see if you recognize it as a text from Kathy?
Oh, Mark. Hey, Nana. Yeah, how can you talk about your daughter like that, right?
Yes.
And ask that defense exhibit number 26 be admitted into evidence.
Any objection?
No objection, Your Honor.
Be received.
In this particular text, is Kathy saying she's done with this? She can't take Collin to school anymore?
Yes.
So that was a specific example of what you just described to the jury.
Yes.
As part of this vacillating back and forth that Kathy seemed to have about whether she wanted to have Collin live with her or didn't want Collin to live with her, did you all agree eventually to a concurrent custody plan?
Yes, we did.
And that was something, did anybody force Kathy to sign those papers?
No, not at all. Not at all.
Were there times when Kathy wanted to cancel the 751 plan, the concurrent custody plan?
Yes.
And then would she change her mind back?
Yes.
Okay, so it's safe to say she wasn't consistent.
She was not consistent.
Yeah, the family scapegoat. It's what the daughter has become.
Obviously, Kathy owned a gun, right?
Yes.
Okay. So at some point, did Kathy give her gun to you to have it out of the home in Fort Charlotte?
Yes.
Do you remember when that was?
Yes, it it's right after the incident where Officer Rentis and Lacey got involved when Collin came back to the home. So that must have been somewhere in the October timeframe of 2023.
Okay. How long did you have the gun at your home and away from Kathy and Collin's house in Port Charlotte?
Less than a week.
Okay. Why did you have it for less than a week?
Because she demanded that I give it back. She said, "It's my gun, you can't have it." And I said, "But we discussed with Officer Rentis and Lacey that I would keep it." "No, it's my gun, you can't have it. And how do I know Nikki won't use it to kill you?"
Okay. So Kathy got the gun back, and
Yes.
so far as you know, she had it with her.
She had told me that she had given it to her next door neighbor, Melanie, for safekeeping. And then a couple months later, she said, "No, Mom, I lied to you. I've had it all along."
Okay. Finally, you had a lot of communication with Kathy on September 7th and September 8th,
Yes.
right? You also had communication with Collin during that time.
Yes.
Did you allow Collin to go to your house in Auburndale when Kathy kicked him out?
Yes.
And why did you allow that?
Because a child can't be just roaming around the street by himself. Collin told me he didn't have gas in his car. And we had like half a tank. That was it. He didn't have his phone. He was using his computer somehow to talk with me. I told him, I said, you have to get to Arvindale before dark because otherwise the gates will be closed. During the day, the gates are open. And go in through the back sliding glass door because you know there's no lock on the back sliding glass door. And I will be there Sunday. Don't talk to anybody and don't leave the house.
At some point, obviously, Kathy, as the jury's heard on some videos, was trying to find out if Collin was actually at your house.
Yes.
When did she finally discover that he was at your house?
I let her know around 11 that night.
On the 7th, so
Yes.
Saturday the 7th?
Mhm.
And how did she react?
She said, you lied to me. And I said, I told you I didn't know if Collin was there. I said, because I don't want you going over there and grabbing him. You just threw him out. Give him some time, give you some time. Let's not have a huge problem associated with this.
And aside from conversations that the jury has heard between you and Kathy over the next hours, did you specifically tell Kathy not to go to your house in Auburndale?
Yes. I said, I will be going Sunday morning. I left first thing Sunday morning. I was going to leave right then, but I was so tired and I have difficulty seeing in the dark that I thought, no, it's better that I wait. You know, in hindsight, I should have gone. But so I waited, I talked to her. She said, no, Mom, I'm going. And that's when she said, I sold the car. They're going to come by and pick it up. I said, you can't sell Collin's car. It's his car. No, I don't care. I'm selling it. I'm turning it into his probation officer for not, because he's not allowed to leave the county, which when I talked to the probation officer, I found out that Kathy had told them that I had terminal cancer. So therefore, Collin could come and visit me anytime I want. I had to tell the probation officer, well, right now I'm only at stage 3, so no, you know, and I'm only in observation, so I'm not terminal.
Okay.
So,
but you personally told Kathy, do not go to Auburndale.
yes, I told her, I said, when I get back, I will give him gas money and I will follow him there, or we can wait until Monday morning. Let's just wait. Don't go there. You don't have permission to go.
Why did you not want her to go to your house in Auburndale?
Because I didn't want her to start a fight with Collin. I was afraid that she would be combative, maybe go after him with a baseball bat, a gun, something.
I don't have any other questions, I don't think.
Thank you.
All right, let's get her. Come on. This better be good.
I don't have any other questions, but Mr. Levine does.
Mr. Levine?
Yep. She's like a robot answering all these questions.
Good morning, Ms. Stedman.
Good morning, sir.
Ms. Stedman, I know you're going through a lot with the loss of your daughter and cancer and everything else. But I'm going to need to ask you some questions if that's all right with you.
Yes, sir.
Now, today here in court in front of the jury, you've talked about that you were concerned that Kathy was going to attack your grandson, and then you listed a bunch of different weapons. But weren't you more concerned that your grandson, who had killed someone before and had been violent countless times with your daughter, weren't you concerned that he was the one that was going to attack your daughter?
No, he had not been violent countless times with Kathy. Kathy had been violent with him countless times.
Now, a lot of the things you've said here today, you never bothered to tell me or law enforcement or anyone.
Objection, Judge, it's improper impeachment.
Oh,
Ms. Detman, as it pertains to your grandson, do you talk to him a lot on the phone since he's been in jail?
Yes,
Okay. Do you do any emailing with him?
I don't email with him while he's in jail.
You-
No,
you
just
prefer
talking
to-
on the phone.
Talk with him? All right.
Yes.
And how many times a week would you say that you talk to your grandson on the
I
phone?
usually talk to him 3 times. I encourage him to pray. I ask him if he's eating. I mean, I'm a dietitian, that's what I do. That he's drinking his milk, that he's exercising in his cell, and most important, that he's reading books. And I keep telling him, you have got to pray. You've got to read your Bible.
Now, I mean, this is an obvious question, but you love your grandson, correct?
Yes,
Your daughter is dead, clearly,
yes,
and she's not coming back, correct?
no,
Now, would you agree that you don't want to see the defendant have to go to prison for a very long time? Is that correct?
I don't want to see my grandson go to prison for something he didn't do.
but he did
All
do
right.
it.
Well, you couldn't make it any more crystal clear that you're up there and all your answers that you've given have been driven by you believing that the defendant, your grandson, didn't murder your daughter, correct?
I am giving clear answers, sir, as to what happened. I know my daughter. That's why I didn't want her coming that day to the house without me being there. I wanted her to wait the next day so that maybe she could calm down a little bit.
You know your grandson too, correct?
Yes,
And you know his history, correct?
yes.
Now, you say you know what happened, but you weren't there when it happened.
No, I'm not saying that I know what happened. I know the possibility of what could have happened. I wasn't there, so I have no way of knowing. I just know the facts about Kathy, having lived with her and worked with her, even to try to maintain her sanity, to try to maintain that she could keep her job as a teacher, to try to maintain that she wasn't trying to slice herself and kill herself,
Okay,
and not coming after my husband with a gun.
Okay, let's talk a little bit more about Kathy. Now, it sounded like she had some mental problems. Is that correct?
Yes,
Now, you would probably agree that it didn't help that she got impregnated when she was just a child, correct?
she was 13. She got impregnated when she ran away from the Hope House, and they found her in the hotel with her boyfriend. It didn't help that her father called her F bitches and that she was damaged goods, and he didn't want anything to do with her.
Ma'am, it sounds like you're really quick to try to throw dirt on your dead daughter. Would you agree with that?
No, not at all. My dead daughter did the best that she could. We have a problem in this country with addressing mental health. We all know that. And that's what she had. She had mental health issues. At times, she was the greatest person on the world,
All
very
right.
intelligent.
I appreciate that, ma'am. I appreciate that. Now, your daughter worked as a teacher for many, many years, correct?
Yes, she did.
And her students loved her, correct?
Yes, they did, for the most part. I mean, as with any teachers, you're going to have some students that, I mean, I'm an educator myself. You're going to have some students that don't. For the most part, yes.
And she cared about her students, correct?
Yes, she did.
She had a passion and a love for teaching.
Yes, she did.
And she taught, predominantly she taught English, correct?
Yes.
And she cared so much about her students that at a certain point, she let one of her students move in when she was married to her ex-husband, Chuck, correct?
Yes.
And then unfortunately for your daughter, Chuck took advantage of this underage student, is what it's believed to have happened, correct? And
Judge, I'm going to object to the relevance of all this.
Approach.
Well, you spoke about all this other stuff that wasn't relevant. Why can't we talk about all this? Let's put it all out there on the floor. You opened the can of worms, Miss Defense Attorney. Yeah, that was a good one, Myron. Not at all. I love my daughter. She had mental problems. I want to see if he asked about, and what did you do to help your daughter with the mental problems, ma'am? What did you do? Did you put her in any facilities? Did you try to help her at all? What'd you do? No, she's not. No, Collin in this woman's eyes is a freaking angel. And we wonder why Collin is the way he is. Maybe the jury's going to see that, y'all, after all this. Maybe the jury's going to be like, no wonder. You know, the jury's sitting back going, I told you, I'm telling you, the dad, it was the dad that he, they're making notes. Can you see the jury when they get in deliberation? They're going to be like, you know, this other person that he had alive, it's got to be the father, right? You know that, right? He is, yeah, Collin is a master manipulator. See, I think that the dad was probably what they say abusive to the mom. And I think that he probably berated the mother a lot, talked down on her, said a lot of nasty, nasty things about her because they went through a horrible divorce, a lot of fighting through the child custody. And he probably, you know, he tainted Collin's mind about his mom. So when Collin goes and he moves in with his mom, he's been away from her for 3 years. He goes back and moves in with her. He's lost all respect for her because of what dad said, right? And dad did this stuff to mom. He watched it growing up of how dad could do this stuff to mom. So now why can't he do it? Apparently, yeah. Apparently grandmother doesn't like her, like the grandfather either. She doesn't like anybody in the family except for Collin. So in grandma's eyes, Collin didn't do anything wrong. Right. That's what I'm saying. What did she do, Anne, to get help for her daughter? If her daughter was that horrible of a person. Stop witness blaming. I'm sorry, was I witness blaming? Oh, shoot, I thought it was allowed just in this trial. This trial alone, you know, because of the way the judge is leaning. Yeah, definitely the trust money. Grandma's got some bank, and Collin knows it. You guys, what if Grandma had been there? Now we know that if Grandma had been there, he probably would have tried to alive both of them, right? So let's say he did. Let's say he did both of them, and Grandma was no longer here. What would that look like if we were who is going to testify? What are they going to say about Grandma when she's not here? How would she like it if somebody was talking about how she was enabling Collin? But you know what else too, you guys? I just thought about this. You know how she was yelling at her mom on the phone? We could hear that in that Ring video. Now we know why she was yelling at the mother, because the mother makes no sense if this is the way she's acting. No wonder Kathy was frustrated with her mother.
I'm sorry we have to talk about some unpleasant things, but it'll be over soon enough.
Thank you, sir.
No problem. So, do you recall my last question?
Yes. You were asking me why I was spilling dirt on my dead daughter, and I said I'm not. I said I supported her. I've gone into massive debt in trying to ensure that she had
I appreciate that, but that was a few questions.
Oh, you're talking about how Kathy ran away from the Hope House and they found her in the.
No, I'm not talking about that either. But if you listen to my questions, it'll get easier. So we were talking about your daughter, that she was a very committed teacher and very committed to the youth of her classroom. And I mentioned that at a certain point, she even allowed one of her students to move into the household, and it was believed that Chuck had an inappropriate relationship with this student. Are you aware of that? With a yes or no answer, if we can start at that place, I'd appreciate it. Are you aware of that?
Yes.
And you were not a big fan of Chuck, as it ended up being the divorce, correct? For how he treated her, from how he impregnated her as a child through the years, being physically, emotionally, and mentally abusive to your daughter. I can't imagine you were a fan of that, were you?
No, Robert was the one that was a fan of Chuck.
Now, ma'am, I understand that you hate your ex-husband.
I don't hate him.
Well, it sounds like you're throwing stuff about Robert in a lot.
You just asked me if I was a fan, and I wanted to tell you who in the family was. I knew Chuck from the time he was.
Ms. Tetman,
Oh, I'm sorry.
that's the point. He gets to ask the questions to elicit the information he's looking for. If additional information is needed, Ms. Thornhill or Mr. Hendry will make sure to address it. So just pay close attention to the question that's asked and try to answer just the question that's asked.
I apologize.
It's all right. Mr. Levine.
Appreciate it. Ms. Stetman, as it pertains to your last piece of information that you provided, as it pertains to your husband, he hated Chuck for what Chuck did to his daughter, that being impregnating a little girl, correct?
No object to the relevance of and to speculation about what Robert thought about Chuck.
Sustain as to relevance.
All right, Ms. Detman, if I ask you a question that for your information, just please answer it irrespective of your feelings about your ex-husband, all right? Now, at a certain point, Kathy got divorced from Chuck, correct?
Yes.
After years of unthinkable abuse, correct?
Yes.
Now, let's move on to a different subject matter. When your grandson lived in Oklahoma with his dad for about 3 years or so, at the end of that, your grandson wanted to come live with Kathy and actually was able to, correct?
Yes.
And Kathy was very happy about that, correct?
Yes.
And she felt that she had missed out, understandably so, on multiple years of her son's life, correct?
Yes.
And she was trying to fix or make your grandson's life better.
She was trying to improve his lifestyle, yes.
Now, you mentioned you described it as a fight in Port Charlotte where law enforcement came because you said your daughter was beating Collin with a belt and made him do sit-ups and push-ups. You remember that?
I did push-ups, and I took away the sit-ups. It was push-ups and putting the weights above his head and running in place.
Okay, thanks for clarifying that. Now, you remember talking to law enforcement when they came out there, correct?
Yes.
And giving a sworn statement because you just wanted both parties, your grandson and your daughter, you wanted everybody to be safe and healthy and happy, correct?
Yes.
Now, Ms. Detman, as to the root of what the issue was that night, do you remember telling the deputy that the three of you were at the dining room table and Susan had Collin seated down and Kathy told Collin that she would be implementing new parenting rules and Collin would be having his Xbox, his cell phone, and other items taken away as disciplinary action due to him being disrespectful to her? Do you recall telling law enforcement that?
I remember telling law enforcement about the Xbox would be, I don't know if it was taken away, but it was going to be restricted.
And at that time, your grandson didn't want to hear from his mom, and so he stood up and threatened to fight her and said, let's just do it, correct?
That was after the incident with the exercising and belt, the beating of the belt. That's when Kathy wanted us to all sit down and eat sandwiches. Like it literally went from one extreme to another. Sit down and eat sandwiches. And then Collin got up from the table and said, let's just do it. And I went to go get my phone to contact Officer Rentis or Corporal Rentis or Officer Lacey.
Okay. All right. Very good. Now, you mentioned that you and your family members love to talk about how violent Kathy was. Is that right?
No, we didn't love to talk about how violent Kathy was. We talked about what we could do to help her. We didn't want her to lose her job. We didn't want her to be suicidal. And more than anything, we wanted her to try to get better.
Did you talk about how violent your grandson was?
No.
And why not? Weren't you concerned about that?
Objection.
Sustained.
Now, you were concerned about where the defendant would live, correct? In terms of who he might hurt, whether he lived with you and your husband, Nikki, or if he lived with Kathy.
My husband did not want Collin to live with us because he said that if Collin lived with us, Kathy would be over at the house and he didn't want to have to deal with Kathy.
Ma'am, didn't Nikki say he didn't want Kathy, he didn't want Collin to live with them because he was afraid that Collin might kill you or kill him?
No.
All right, now let's move on to the subject matter of kitchen knives or butcher knives. Do you tell the jury about the time when you noticed that there was a knife missing from your residence there in Auburndale, and you were trying to figure out who stole the knife or who took the knife?
Yes, there was a small knife with a blade like this that I bought in the dollar store, which is now like the $1.29 store, and it had a protective cover on it, and it wasn't in the drawer with the rest of the knives and silverware.
And did you find out eventually that your grandson had taken the knife?
Yes.
And he basically told you he just needed it just in case, and did not elaborate on what he was going to do with it?
He said he just needed it.
Now, at that time also, Kathy made it explicitly clear to you that she was afraid that the defendant might hurt her, correct?
Not at that time, it was later.
And there was multiple times when Kathy let you know that she was afraid for your safety and for her own safety.
Yes.
Now, you mentioned that a couple of things about the 7th and the 8th of September. You mentioned that Collin told you that he didn't have a phone with him on the 7th. Is that correct?
Yes.
Were you aware that he did have his cell phone with him and it was in his car?
So his cell phone had been turned off by his mother. She used to do that anytime she'd kick him out. She'd turn the cell phone off. In fact, it's in the records that she turned it off, and she turned it on, and she turned it off.
And you mentioned that the sliding door, that it had no lock on. Is that correct?
We had adapted the sliding door for a doggy door so Freddie could go in and out when he was staying in Auburndale, my acid house. And so it did not have a locking mechanism. You could close the door, but you couldn't lock it.
And so that's how you mentioned that your grandson was able to get into your house on the 7th?
Mm-hmm. Oh, plus the front door was, I don't believe in locks. I've been burglarized and the burglars got in quicker than I could find my lock. I don't lock things.
Okay. Now, your response when this was going on, when law enforcement made contact with you, was that you didn't know that Collin was a psychopathic killer, correct?
I never said that. Never.
If I may approach, please, Your Honor.
Grandma is coming off as a complete liar.
And I'm going to show you page 59 of 67 of her statement on September 8th.
Let's see it before you approach.
I'm sorry?
I wanted you to see what he's
Thank you.
referring to before you approach.
And if you could just take your time and read the highlighted portion to yourself.
For one thing, I don't use words like stupid, Colin. I would never say that.
Oh, ma'am.
He just wants you to
Oh,
read it to
okay.
yourself.
Oh, I'm sorry. I'm sorry.
That's all right. That's all right.
We may need to go sidebar real quick.
Oh, of course you do. You got to rein her in, don't you?
Finish reading it.
Yes, uh-huh.
Approach sidebar.
Her face was getting red. Oh, yeah. Grandma's getting upset. She didn't like this. Excuse me, Judge. My witness is saying things that are not rehearsed. She's speaking out of turn. I need to pull her in a little bit, please. Thank you so much. Sure. Whatever you need, Miss Thornhill. I think the prosecution is doing pretty good. I think he needs to go at her a little bit more now. He hit her early on. He's kind of let off a little bit, but he needs to go back at her harder. He's calling her out, but I think he can still go harder on her. Mark said, really and truly, they just got a bar in the back. They're all going in back and doing shots. Right? Well, you guys, I'm telling you, the attorneys are the ones hiding Collin. They probably told him, push your chair back because we don't want the cameras to see you. But they're definitely hiding him from the cameras, which I get that. I want to see. I just want her to slip. I wish they'd take like a break or something and then they call her back up or even bring her back. Can they bring her back up on rebuttal? Even though she's not their witness, they could still bring her back up in rebuttal, right? The state. And they could figure out a way to make her slip up about the dad. Exactly, Louise. They can hide him from the cameras over here, but the jury can still see him. Oh, Shelley thinks that the prosecutor's just getting started. He's just warming his engine up. And then he's going to get her gasket to explode. Gladys, why do innocent people have to hide? I know, right? Grandma's just not coming off as credible to me, you guys. She just seems too eager. Too eager. She's a horrible actress. Exactly, Myron. You well said. I'm hoping that somebody figures out an ingenious way to ask that question where she says something about his father. It's gotta be. This kid gets out, whoever he ends up living, whether it's a roommate, a wife, or even if he lives with grandmother for a while, that person is not safe. This is the only witness the defense has. No, Shelley. They read out all of the mother's siblings. She's a bunch of siblings and step siblings, and I believe they're going to call all of them up. They also have Collin has an older brother, so we may also hear from him as well. Now, you guys, if we get into this and the whole family is doing the same thing as the grandmother, ugh, that's going to get sticky. I don't think it's going to be that bad, though, is what my grandmother's doing. I think so, too, Nana. I feel like the way she's so eager to trash her daughter, it's not that she's trashing her daughter. It's that she's so eager to do it. So, like, there's other ways she could have said it. She could say, I love my daughter. I did everything I could for my daughter, but this is what my daughter did. No, she didn't do that. My daughter's crazy. My daughter this. My daughter. She just came out of the gate. Like, she was literally like a racehorse waiting to run. And it was so obvious. The older brother, I don't know. I think the older brother, I'm curious to see how he's going to be. Like, I feel like the older brother would be more neutral, but I don't know. It's her tone too. Exactly. Yeah. Well, she's very monotone. Oh. Okay. So what I was going to say about the whole thing, she was like, she's saying that he would do exercises for punishment, that mom made him do these exercises for punishment. You guys, we saw that video of the way he dismissed his mother constantly. Just one day's video. And I could tell you right now, there's no way this kid was doing exercises because she told him to. He would have said, forget you. I'm not doing that. And if Kathy was so mentally ill and grandmother was so worried about that, then why didn't she fight to get custody for Collin? She couldn't, because the man that she was with in her life at the time, she had to put him first over her children, because that's what grandma does, apparently. And I wouldn't doubt that Kathy was being abused at some point by somebody that she brought in the home. I wouldn't have doubted that at all. Because it seems like grandma would have believed the man over the children. She's that type of mom. No wonder grandpa left her. Yeah, this is a huge difference from what grandpa said. You know, what I probably will do is during the break, I want to pull up grandfather's testimony so we can watch it. It happened, I got to look for that what day it was. It just came out on Thursday. I mean, on Friday. I've got it marked. So y'all remind me if I forget. We're going to watch his testimony again really quickly. That's a really good point, True Crime. I don't think she could have maintained her teaching job if she was as mentally ill as they all portray her to be. Yeah. Hi, Fabulous 60 Show. Yeah, that's what everybody's saying. There's a hit list that Collin has. He's beyond special, Shelley. This kid is not special. This kid is very sick. You better be quiet, Mark. I'm going to smack you. You had a live on Friday. Yes, we were live on Friday. Where were you? Oh, that's right. You were at the casino. What did you win? Did you win anything? Yep, Myron's thinking like I am. Let's listen to what grandfather said and compare it to what grandmother says. And see if they're completely different. None of this makes sense. I mean, we knew they were setting the stage to really paint the mom as just this horrible, crazy person. And I definitely expected it from the defense attorney. I did not expect it so much from the grandmother, her own mother. That just blows me away. Yeah, who thinks that Collin was doing push-ups because his mama said so? Put a 1 in the chat. Put a 2 if you think, yeah, he didn't do that. I mean, it could be, guys, that they have a gene that in their family that is definitely some mental stuff going on here. I don't know. It sounds like the whole family just has got problems, issues. It's funny how whenever they call a sidebar, it's always because of it's never it's a sidebar with the prosecution is like short and to the point. Sidebar with defense in this trial, it's like they go out and sit and have tea and crumpets or whatever they call it. They're having tea and cookies. What do they call cookies and what do they call them? Biscuits. They're having tea and biscuits. Dysfunctional. That's the word I'm looking for, Gladys. Thank you. Dysfunctional family. Yeah, Fabulous 60s. You can get Marcus now set up the fan club for the defense attorney. If you want to join that, he'll tell you how you can do all that because he's got all that in his timeout room. Yeah. Can't stand her either. Tea and scones. Tea and yeah, adult beverage. Oh, come on. Yeah, you can't say the K word. We can't say the M word. We have to be careful. They can do it on Disney, but we can't do it here on YouTube. So please be careful. The whole family's off the charts. I think so, Nana. I think so too. Grandpa flat out got up and said Collin had a very harsh statement about wanting to unalive those biatches. Said it just like that. And too, when the defense attorney tried to come back and snap back at Grandpa, he was not having it. He was a good witness. He was a really good witness for the state. Maybe the state will call him in rebuttal. I now want to hear about the character of Grandma. If we've heard about everybody else's character, they're throwing the entire family under the bus. Let's get them all. And you wonder why these kids end up the way they are these days. You got all these family members pointing the finger at each other, blaming each other for everything in their lives. But no one's helping one another. Well, they're not saying it was self-defense, Nana. Because remember, she fell. She fell on the knife. He didn't stab her. Oh, Shelley says the grandmother's trying to make the jury sound like he did it in self-defense. So he was so. Now remember that self-defense is the same self-defense he had in his father's unaliving. He said that his father was abusive to him, would not let him leave the compound. I think is what he called it, or the prop. Maybe he said the property, and he only got fed once a day. If I'd have known this was going to take this long, we could have watched a body cam video. Yeah, the father's the only one that stood up for his daughter. Okay, finally, here we go.
All right, thank you, Ryan.
Ms. Dedman, we're almost done, all right?
Thank you.
You're welcome. Ms. Dedman, is it a fair statement that Kathy had expressed to you that she was getting very frustrated with the fact that your grandson wouldn't do his chores, was disrespectful, and was basically just taking his mom for granted?
Yes.
And when Kathy was communicating with you on September 7th and September 8th, that was the Saturday and the Sunday, she did so by both text messages as well as phone calls, correct?
Yes, sir.
And Kathy made it clear that she wanted your grandson home by 10 a.m. on Sunday, correct?
Yes, sir.
And then when that didn't happen, when 10 a.m. came and went, she still made it clear that she wanted your grandson to come home, correct?
Yes.
And Kathy mentioned that she wanted him home. She wanted him to go get work at Domino's from like 4:30 to 8 or 8:30 on Sunday, correct?
Yes.
And your grandson was working at Domino's, correct?
Yes, he was.
And so Kathy wanted him home so he could then go to Domino's that night, correct?
Yes.
And then kind of towards the end of the communications, then Kathy told you she was going to your house to get Collin to come home, correct?
Yes.
And she told you that either he could go home with her or he could drive, basically follow her in his car, correct?
Yes.
All right. Thank you for your time today, Ms. Dedman.
I have no regret.
Witness release.
Yes, sir.
Yes, sir.
Thank you.
Thank you.
Hub, you can't type those words in the chat. I'll get in trouble.
No, sir. That's right.
Rest. There being rebuttal, Mr. Levine.
No, Your Honor.
Ladies and gentlemen, both parties have rested their cases. The next phase would be closing arguments, followed by your instructions on the law and then deliberations. Closing arguments in these types of cases are typically not short. Also, I need to have a conference with the lawyers regarding the jury instructions, although it is up to me to decide what laws apply and how you should be instructed. They do have a right to give input. That conference could take some time. So if we did all of that in closing arguments, we would be sending you out probably mid to late afternoon. And I don't want to do that to you. So I'm going to give you an early day today. We are going to work the rest of the afternoon to get all of those strings tied up so that tomorrow morning we'll begin directly with closing arguments, and then the instructions will already be finalized, and you will be probably going to deliberations around lunchtime, I would imagine. So you're going to have an early day. Now, although you have heard all of the evidence, actually, I'm not quite sure about that. Give me just a moment. Would you approach just sidebar real quick?
I understand it's difficult to talk around all the restrictions, Hub, but if you keep saying words that we're not supposed to say, it's gonna hurt my video. I'm gonna get in trouble from YouTube. So you just have to put like little asterisks in there instead of spelling the word completely out. Change some of the letters around. We say red rum a lot. We say
Our
unalived.
schedule, ladies and gentlemen, so before I dismiss you,
Self-harm.
I just need a few minutes with the lawyers outside your presence, so if you would just wait for us in the hallway for a moment.
All right, please.
I'm floored too. I can't believe they've already arrested. Okay, so apparently none of the other family would say anything. That is crazy to me. What does it say that the brother doesn't want to testify on either side? That he's torn? I don't know. I don't know, guys. I just feel like why wouldn't the rest if she why isn't the rest of the family stepping up? This is a big deal. I mean,
Mr. Griffith, would you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. I did not ask you about whether or not you wanted to give testimony in this case, so I need to talk to you about that. I assume, based on your lawyer having rested, that you did not want to testify. Is that correct?
No, Your Honor.
That's not correct, or no, you did not want to testify?
I did not want to testify, Your Honor.
And have you talked about that with your lawyers today?
Yes.
And you talked about it with them on more than one occasion?
Several, yes.
And did they answer any questions you had about whether or not you should testify and address any concerns you had about doing one thing or the other?
Yes, Your Honor.
All right. And do you need any more time with them before you answer my question in a few minutes about whether this is your final decision? Do you need any more time with them?
Take a minute.
All right. So he can, Mr. Larson, if he can take them to the jury room.
47.
I don't think he's going to testify. He's this cocky little crap that likes the attention. He's just dragging this crap out. That's what I think. I cannot believe that this is it. I get what you're saying. Maybe the rest of the family's like, I don't know if it's a fear of Collin, Louise. I think maybe the rest of the family's just like, I don't want to talk against either one. But at the same time, wouldn't you want to at least defend somebody, defend your sister, defend, I guess if I was a family member and I just watched what grandmother just did, I would be like, wait, I need to go testify now. I need to come up. So wait, does that mean the state is not going in for a rebuttal? Or it's just that we just got because the state said nothing more, right? I'm confused about that. Yeah, he's stalling. Yeah, good point, Prissy. Longer the trial, the less time he's in behind bars.
Griffith, you've had just a few minutes, I assume as long as you wanted to talk some more with your lawyers about this, correct?
Yes, Your Honor.
And they answer any additional questions or concerns that you have?
They did, Your Honor.
Do you have any questions of me about your right to testify versus your right to remain silent?
No, Your Honor.
And it is your right to remain silent, and I'll be telling the jury that you're not to be concerned by that or view it as an admission of guilt. But one thing I need to make certain of is that you understand that this is your choice in this case. You understand that?
Yes, Your Honor.
There are many things your lawyers can do without your permission, things they can do that you disagree with, even things that you speak up and tell me you don't want them to do. But not this. You understand?
Yes, sir.
Have they explained that to you, that no matter what they think, it's your decision?
Yes, sir.
Now, they are supposed to give you some advice and counsel about what they think you should do. Are you satisfied with the advice and counsel they've given you?
I am.
And today, are you under the influence of anything, drugs, alcohol, or medicine?
No.
And any concerns related to competency? Have any of those arisen over the weekend, Mrs. Hornfeld?
None.
Mr. Hendry?
No, Your Honor.
And has anyone, including either of your lawyers, promised you anything or threatened you to keep you off the witness stand?
No.
This is your choice and your choice alone?
I know.
Is it?
Yes.
And you do not want to testify?
I do not.
Anything else you want on the record?
No, sir.
Mr. Hendry?
No, Your Honor.
All right. Okay, we can have the jury. I find that your choice is freely, knowingly, and intelligently made, and that it's made upon the advice of competent counsel.
And Your Honor, we're not raising additional argument on judgment of acquittal, but we would maintain our previous motion.
Same rule.
Oh, I'm sorry. I wasn't on mute when I was eating. I guess so. If I was part of the family, I'd want to get far away from this. Especially with it being on TV. Oh, God. Yeah, the prosecution's questions were thrown out. State would get objected and sustained. So now what are they going to do? Just jury? If they do jury, what do they call that? Questioning. What do they call that? I forget what they call it. When they read the rules to the jury. Instructions. Thank you, Baba. I couldn't think of. So now they're going to do jury instructions. And they're going to figure those out. They'll probably end up closing out early today then. The defense talked like they were going to have more witnesses, though, last week, you guys. They did talk like they were going to have more witnesses. Okay, so I have a question. Do you guys want to watch jury instructions? Would you rather watch, like, body cam and all that? Oh, you guys are going to make me want a Subway. No, what I really want is a Firehouse sub, but they don't have any near me. Baba says body cam. Yeah, I'm not crazy. Then they did say that it would make it sound like it was going to be a bit. That was just her pulling her games again. Judge released the jury for the day, so the closings will be in the morning, I guess. Everybody wants body cam. Nobody wants to watch jury instructions. We'll watch a little bit. How much do I have of body cam? I mean, the body cam's really not that long. Jury instructions are always boring. We'll watch a little bit of it, and then when we get to that point, we'll switch it around. I just don't want us to miss anything really important. Especially, yeah, they did. The prosecution and the defense rested. Like, if you'd have blinked, you'd have missed it. But wait a minute. Jay Witt says, won't the jury be too confused to make a decision? Okay, Mark, you be good. We'll see you tomorrow. Thanks for coming in, honey. So what if what if we get into jury instructions, writing the jury, going through the jury instructions or whatever, and Miss Thing pulls her little bias thing with the judge, and the judge is like, well, it might take them 2 days to write the jury instructions. Well, Judge, oh, yes, you're right, Miss Defense Attorney. Thank you for keeping me on my toes. Yeah, I was thinking that too. Just let the feed run for the people who like the boring stuff. Some people do enjoy watching it, but I feel like they would definitely. There's going to be some stuff in here that we want to hear as far as what they're going to allow to say to the jury and all this and that. Because you remember, we got to talk about the dad. The man we're not supposed to talk about, the dad. You got to whisper that part. The dad. We don't want to upset the judge or the defense. So everyone's on Collin's side. The prosecution questions was shut down by the judge. Grandma dotes on him. He can't do no wrong. He's so protected by everyone. And the victim was on trial. Pretty much, yeah. So, should the jury vote to convict the mom or the son right now? I'm just kind of wondering. Jury's back in.
All right, ladies and gentlemen, as I was saying, although you have heard all the evidence in this case, you still have not heard the arguments of the lawyers or the instructions on the law. So remember, it's not time to think about how you might decide the case or to formulate any opinions about the merits of the case. Also remember to avoid the news as I previously instructed you, and to avoid talking about the case with anyone or looking anything up. Now, tomorrow you'll be receiving this case for deliberations. I want to remind you that a jury may deliberate as much or as little as it feels necessary to that particular jury to do so. But what that means is that it's possible your deliberations could go past 5 o'clock if that's what you all agreed to. It could be earlier than that, but the point is you may want to let those who would normally be expecting you after 5 o'clock, that if you're not home, that the jury has chosen to continue deliberating. So just keep that in mind. Also, if you've been bringing your lunch during jury service, you may still do that, but I want to advise you that the court will be providing you with lunch tomorrow, because I anticipate you will begin your deliberations around lunchtime. That way you won't have to separate, because you won't be allowed to deliberate unless you're all together at the table in the jury room. That will facilitate your deliberations beginning as soon as possible. So I hope that you enjoy the rest of your day, and we will see you tomorrow morning at 8:30.
All right.
Mark, that's awesome. Okay, folks, so here's the jury verdict forms. No need to fill them out. Defense has already done that for you. Judge has approved it. Just hang out a little bit, okay? We'll get back to you in just a moment. Oh, and by the way, here's a free lunch. Oh, and then anybody else? Can anybody, by the way, the defendant needs a place to stay tonight. Can anybody give him a place to stay?
Did you want to break before we take up jury instructions?
Whatever the court's desire.
I'm ready now.
All right, I want to make sure everything gets a sufficient break before we start that, especially the court reporter. So we'll just take 5 minutes for a comfort break.
I do feel like it's like, okay, we're going to talk about mom, the defendant. Oh, I'm sorry. I mean, the victim. We're going to talk about the victim. Oh, I'm sorry. I mean, the defendant. Do you guys feel that or not? Closing arguments Tuesday morning, 8:30 Eastern time. Yep. They're going to show all the rest of this though now. It is confusing. The defense has judged mom guilty. Reporter needs a new can of paint. You know, it's like I don't know. It's not just me, right? I'm not just being dramatic, right? So Ann wants to know, let's take a vote. How long do you think the jury will deliberate? Will they come back tomorrow with the verdict, or will they come maybe Wednesday? Because, you know, they'll get into the jury room about noontime. I'm dramatic. Oh, yeah. Nana says 3 hours or less. Carol Van Meenan is apparently she's back on replay because she said she is definitely reading her answers. That's funny. Yep, girl, that's what we said too. Oh gosh, that's horrible. I really don't want them to come back tomorrow. I want them to go to deliberation tomorrow, and then I want them to come back on Wednesday because I need to go run an errand Tuesday. If they go late, yeah, I'm not going to be held hostage to this damn court system. Now that's dramatic. As God is my witness, I will not be held. Bottom line, no matter how crazy mom was or wasn't, did she really fall on the knife? No, she did not. Bottom line is, Patty, thank you for getting me in line here because I was kind of off center. Bottom line is that he did it. There's nobody saying he didn't do it. I mean, really, there's really nobody saying he didn't do it. I mean, you could say he fell on it, but you know, they know he did it, right? So all we've heard is people say, well, he did it because she deserved it. Well, the prosecution still proved that he did it in this case. There's no reasonable doubt here, right? But my fear is that considering all that's been said by grandmother and everybody else, this kid's going to get a slap on the wrist. And he's going to be another one of those statistics where they're going to let him out early and he's just going to do it again later in life. Right? So if that would be horrible. That would be really horrible. I mean, they literally, somebody like him, I think even if you've not been convicted, if you've been accused of unaliving 2 people in your lifetime, especially before the age of 20, you ought to be on some kind of registry so that I can look you up and know if you're near my house. You know? It'll be a girlfriend. It'll be a wife. Whoever gets in his way, Somebody said a boss. Could be a boss, yeah. He could walk away from a boss, though. Thinking girlfriend or wife. This kid is going to do it again. You know what they didn't have in this trial? Just thought about this. And again, it could be because it was a speedy trial. They didn't have anybody come up and talk about his psychology. Get past all the fancy. And I think there's some women on this jury. I think there's going to be a lot of people in this jury who are going to be like, let's stop victim bashing, because that's not what this trial is about. Michelle's got faith in the intelligent jurors. I hope they do a good job here. I wish the jurors were the ones giving the sentencings too, though. Oh, Nana says, well, he could do it in prison. And even if, though, think about this, even if he gets the lighter sentence, we still have Oklahoma. Oklahoma could come through for us. This kid does not need to be running the street. This kid does not need to be released, you guys. He is a danger to society. I don't even know if they had him examined. Surely they did. Surely somebody had him examined. But yeah, he does not need to be released back into society. I'd be terrified if he lived in my neighborhood. Seriously.
For the record, these instructions were proposed by the state. All instructions that have been given so far will go back. We will start this morning with 2.3 stipulations. I have included the exact language from the written stipulation that you handed to me and that I read in court as part of that instruction. Is there any objection to that? Mr. Whitney?
No, Your Honor, thank you.
Ms. Thornhill?
No objection.
That takes us to 2.7, closing argument. That appears to be standard. Is there any objection?
No, sir.
3.1, introduction to final instructions is standard. Is there any objection?
No, sir.
3.2, statement of the charge is standard and accurate. Is there any objection?
No, sir.
It seems like the substantive instructions on the crimes are at the end, but they would come next. And then we begin with 7.1, introduction to homicide. That is a standard instruction. It states what appear to be the appropriate lessers.
Yes, Judge, hold on, let me get to it since I didn't reorder that. It does appear to be standard and accurate.
No objection.
No objection.
All right. 7.2, first degree premeditated murder. Appears to be the standard instruction. Is there any objection?
No, sir.
7.3, first degree felony murder. Appears to be standard. Is there any objection?
No, sir.
That takes us to 7.4. Well, after that, I would get when there are lesser included crimes or attempts. That is back up. Here, and again, then it states second degree murder and manslaughter as the lessers.
Those are the category 1 lessers.
Any other lessers requested?
No, sir.
All right, and then for kidnapping, false imprisonment.
Correct. Also a category 1 lesser.
Any other lessers requested as to kidnapping?
No, sir.
All right.
Manslaughter, lesser. Yep, if
All right,
it would be the
second
judge and the
degree
defense
murder
attorney.
appears to be the standard instruction. Is there any objection?
No, sir. There doesn't appear to be a manslaughter instruction in the packet.
I don't have it either. Let me pull it from the Florida Bar website. Give me just a moment.
No, not that.
To me, I did think that was kind of weird, but what's the point? I mean, you're already going for murder. I'm sorry, red rum. Oh, let's hurt myself.
We get there. Kidnapping also comes before when there are lesser included
Right.
crimes or attempts. Is there any objection to the kidnapping instruction as proposed?
No, sir.
All right.
I'm with you, Sue Joy. I agree. Trust me, you're not the only one saying it. Well, yeah.
So since the state did not include 7.7 manslaughter, is the state asking to proceed on just manslaughter by act, element 2A?
Yes, sir.
Do you agree with that?
I do agree with that.
All right, so it will read to prove the crime of manslaughter. The state must prove the following 2 elements beyond a reasonable doubt. Kathy Griffith dead. Have you been putting her middle name in?
No, Your Honor.
And then I will take out the A, the letter A. Element 2 will simply read Collin Griffith intentionally committed an act or acts that caused the death. Kathy Griffith.
They have a point system that they use.
And then the next paragraph, every person has a duty
for sentencing.
to act, reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant may not be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously explained to you. In order to convict manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable and which caused death. And that's it, correct, Mr. Levine?
It is, and thanks for taking care of that, Judge.
Ms. Thornhill, you agree that's all they should be instructed on?
I do agree.
Just a moment.
All right, I just put it in the chat. 9 years and 4 months. If is the minimum for manslaughter, okay? First degree is life in prison without the possibility of parole. Because remember, we don't have parole in Florida. So all the lessers, y'all don't like all the lessers being on there because it just confuses the jury.
9.2 false imprisonment, which appears to be standard instruction. Is there any objection?
No objection.
All right. Maybe back up.
Judge, do you read excusable homicide and justifiable use of deadly force after the lessers or after introduction of homicide, or?
Well, I generally read that after all lessers, unless you want it someplace else.
Nope.
Mr. Levine?
I'm fine with whatever the defense requests, Your Honor.
And so that would come next. Let me pull up that instruction. I have it up somewhere, I think, this morning.
I just put this in the chat, but I'll say it again. Like, this is huge if they do manslaughter. Because you're talking about the difference between 9 years versus life.
By the defense, just have the whole kitchen sink in, so we need to talk about that.
Yep.
Just
9 years for Collin would mean that he would still be getting out of jail before he turned 30 years old. I don't know. I feel like because this was a speedy trial, it's a huge difference in how this is being done, how this is being handled, versus something that was planned and prepared for.
so it should, the title should just be justifiable use of deadly force, correct?
Correct.
It is a defense. You're claiming self-defense only as to count 1, correct?
The first degree murder, yes.
It is a defense to the crime of first degree murder if the actions of Collin Griffith constitute the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm.
Justifiable force.
Collin Griffith does not have the burden of proving that he was justified using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. Collin Griffith was justified in using deadly force. He reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself, correct?
Correct.
And you are not requesting or the imminent commission of some applicable.
No, because the applicable forcible felony would be aggravated battery, which indicates death or great bodily harm, so I think it's unnecessary.
The jury did not get to hear all the stuff that was said by the DCF workers and all that. It's huge information.
Dispute about duty to retreat and which instruction I give on that, Mr. Levine? There's either Collin Griffith had no duty to retreat before using deadly force, or the one that begins if Collin Griffith was not committing any crime other than the alleged, I assume I would say kidnapping. No. You tell me. That's not right.
I don't think he had a duty to retreat. He was in a place that he was allowed to be, in fact, was living there, so it's like it's his home.
Mr. Levine?
I don't disagree that the defendant did not have a duty to retreat. Of course, I said in the context of the defense advancing the self-defense.
I understand. All right, so we'll simply read Collin Griffith had no duty to retreat before using deadly force.
I want a retrial already. I don't agree with the way this trial was done.
Second part here again. Oh, because it was an indwelling. So Ms. Thornhill, that next section is similar. To the paragraph which reads, Collin Griffith was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself or others. But then this next section encompasses the same context, but the same law, but in the context of stand your ground. I don't think both need to be given, but is this what you're requesting, or just the simple?
I mean, I would rather have both, just in case the jury thinks that he didn't have a right to stand his ground in this house that he had a right to be in. I realize it's somewhat duplicative, but it's the standard and that's what is allowed for. It doesn't say give this or this.
Mr. Levine?
No objection.
All right, so the next part we'll read. Collin Griffith was in you want a dwelling or residence?
Residence is fine.
Was in a residence in which he had a right to be. He had no duty to retreat and had the right to stand his ground and use force, including deadly force, if he reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to himself.
That's correct, and B is not requested.
The state's case was just, it could have been so solid on this, you guys. It could have just, you could have walked out of hearing and just said, oh, yeah, there was no reason for this.
The next section is not applicable, correct? Or are you asking for that? The use of deadly force is justifiable if defendant reasonably believed the force was necessary. I'm sorry. Yes, to prevent great bodily harm to himself while resisting any attempt to murder him, commit a forcible felony, or commit a felony upon him, or commit a felony upon or in any dwelling in which he was present. Are you asking for any of that?
Well, and once again, Judge, it seems duplicative, but since it's not in the disjunctive, and it's entirely possible the jury could believe that Kathy was trying to murder Collin or at least commit an aggravated battery upon him, I would request it.
Mr. Levine?
No objection.
All right.
Yeah.
All right, so we'll read the use of deadly force is justifiable if Collin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery upon him.
Yeah. Can we also add aggravated assault?
I don't object to the aggravated battery. What was the context, Your Honor, again, of the aggravated assault request by the defense?
They wanted to read the use of deadly force is justifiable if Collin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery or aggravated assault upon him.
No objection.
But the last paragraph you're not asking for.
No, C,
Yes.
correct, I'm not asking for that.
This next part about law enforcement and excessive force is not applicable. You agree?
I agree.
Now, in deciding whether Collin Griffith was justified in the use of deadly force, you must consider the circumstances at the time force was used. The danger need not have been actual, however, to justify the use of deadly force. The appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary, moreover, to justify the use of deadly force. A reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force, was necessary. Right, this next portion about presumption of fear is not applicable, correct?
I don't think it's applicable, Judge.
is the next portion of those A through D paragraphs, correct?
I agree.
Good point, Shelley.
A presumption of intent to commit an unlawful act, agreed.
I agree that that is not applicable.
And you need to define residence, correct? But not dwelling, since we haven't chosen that.
Right, I think
Do you
residence.
agree, Mr. Williams?
No objection.
I do not need to define vehicle, correct?
Correct.
All right. And then there's this part. However, the use of deadly force is not justified if you find that Collin Griffith was attempting to committing or escaping after the commission of an applicable forcible felony. Am I getting that?
I am not.
Yes, sir.
Okay.
Or kidnapping, correct?
Yes, sir.
Is there an objection?
No.
So I don't know about the point system, but the judges have to follow some type of point system when they give a sentencing. They really don't have. Yes, they have authority, but
However, the use
look at that
deadly
kidnapping
force
charge.
is not justified.
I don't think that.
I don't know that that applies, does it, Mr. Levine?
No objection.
All right, so that whole section comes out. All right, and then I'm assuming you want prior threats or difficulties.
Yes, please.
So that would be if you find that Collin Griffith, who, because of prior threats or difficulties with Kathy Griffith, had reasonable grounds to believe that he was in danger of death or great bodily harm at the hands of Kathy Griffith. You may consider this fact in determining whether the actions Collin Griffith were those of a reasonable person. If you find that at the time of the alleged first degree alleged first degree murder, should it also say the lessers?
As with the previous section in the same instruction, it could say first degree murder and all included lessers.
If you find that at the time of the alleged first degree murder or any lesser included offense, Collin Griffith knew that Kathy Griffith.
And Judge, I'm sorry to interrupt. The state's proposed instructions uses Catherine Griffith, so we should probably be consistent throughout.
All
I'm
right,
sorry.
I'll make that
Yep.
change
Got it.
before I finalize it. Thank you for that. Catherine Griffith had committed an act or acts of violence. You may consider that fact in determining whether Collin Griffith reasonably believed it was necessary for him to use deadly force. as to these two reputations, are you asking for one or both?
Both, please.
Mr. Levine?
No objection.
All right. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, and that her reputation was known to Collin Griffith, you may consider this fact in determining whether the actions of Collin Griffith were those of a reasonable person in dealing with an individual of that reputation. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, you may consider this fact in determining whether she was the initial aggressor. Then, in considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Collin Griffith and Catherine Griffith. And that is it, correct?
Yes.
Any other comments, requests, suggestions with respect to justifiable use of deadly force?
No, sir.
All right.
And one quick question, is it my understanding that all the proposed subsections of justifying the use of deadly force have come from the standard jury instruction? There's no special request by the defense?
No special requests.
Everything, what was sent to me by Mr. Thornhill appeared to be directly copied from the Florida Bar website. So.
Yes, it was.
All right. Moving back up.
So then would excusable homicide follow that?
I read, are you talking about introduction of homicide?
Yeah, that there was actually an excusable homicide instruction that was provided in the packet that the state.
Where is that?
I don't remember where it is.
Homicide, the introduction to homicide portion, I'd have to scroll down to confirm, but.
I didn't see that in the copy. I mean,
You're right.
excusable homicide is included in the introduction to homicide.
But it doesn't give the explanation of what the circumstances are under which it would be excusable.
It was an incomplete instruction. I have the killing of a human being is excusable and therefore lawful under any one of the following three circumstances: when the killing is committed by accident or misfortune, in doing any lawful act by lawful means with usual ordinary caution without any unlawful intent, or two, when the killing occurs by accident and misfortune in a heat of passion upon any sudden and sufficient provocation, or three, same thing, if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. Is that what you were?
Yeah, that's what I'm requesting, and maybe it just is part of introduction to homicide, it just.
I think what it was is, because the standard instruction has the two sections, justifiable and excusable, and they're all caps in the standard instruction, and probably what happened is
Just second page.
went to a second page, but that's in there. All right, after self-defense, are there any aggravator instructions that need to be given for weapons or anything like that? I didn't see any.
Your Honor, I think in the verdict form, there's special findings, and you're right, there should be an aggravator as it pertains to the knife and the weapon, but I don't believe that I remember to include it.
aggravation by carrying, displaying, using, threatening to use, attempting to use a weapon. And was that charged in the indictment?
Yes, sir.
Yes. Sure.
Just to count one, I believe.
Yes.
I think the fact that she tried to leave and he wouldn't let her is a big deal. If I'm the jury, hang
I'm
on.
sorry?
It's 3.3A. Do you object to that instruction being given?
No.
Let's hammer that one out. Quick. All right, so that will read if, well, it will be aggravation of, now, Mr. Levine, I had this discussion with, well, he's a juvenile, so I think it is appropriate in this case. So it will be aggravation of
Still referring to him as a juvenile.
first degree murder, second degree murder, and it does apply to manslaughter,
Yes,
correct? Because it's a level enhancement, correct, not an amendment.
Correct.
So it does not apply to first degree murder. I don't think that prosecutors take a different, I mean, there's,
As it
it's a
pertains,
capital crime, so I mean, you can't.
Right, you
really
can't enhance it.
and on my verdict form, if I remember correctly, I don't have a special finding as it pertains to first degree murder.
So it should be aggravation of second degree murder and or manslaughter, correct?
That's acceptable.
You agree, Ms. Thornhill?
Yes.
By carrying, displaying, using, threatening to use, or attempting to use a weapon. And it will read, if you find that Collin Griffith committed second degree murder or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, you personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of first degree murder with a weapon or second degree murder with a, second degree murder with a weapon or manslaughter with a weapon. Agreed?
Yes.
Yes.
I don't need to define firearm,
That is correct.
and then I'll define weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or to any other object. Do I need to do any other object?
No, I think it's,
Pretty clear.
yeah, we're
Do you
doing
agree,
the knife.
Mr. Levine?
I agree.
All right. Then the final paragraph, so I'll take out the one as well, so it will just be one sentence. Then the final paragraph, you find that Collin Griffith committed second degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of second degree murder or manslaughter, correct?
Yes.
Yes.
All right. There is no instruction on the issue related to juveniles. It's just a verdict form issue, correct, with the findings of actually killed, intended to kill, or attempted to kill, correct?
Yes, I agree.
All right, so that will take us then to 3.7, plea of not guilty, reasonable doubt, proof. This is the new standard instruction, I believe, correct?
That I don't know.
Well, it may not be, and I thought, because I've been giving this instruction by memory now for probably 15 years, but I never noticed until recently that first sentence of what a reasonable doubt is not. I never remembered it saying proof beyond a reasonable doubt does not mean proof beyond all doubt. I thought it just started with a reasonable doubt is not a mere possible doubt. So I think this is new. Any objection?
No.
All right. And I am assuming, Mr. Levine, that is pulled from the most current version on the website.
That was my intent, Your Honor.
All right, let me look just to be doubly sure.
In my office, I wouldn't say it was necessarily pulled from the website, but pulled from our computer that is supposed to be the most up-to-date jury instructions originating from the website.
And it's in there. It's on the website. That does appear to be new standard language. Oh, yes, it was amended May 2024. All right. Any objection to reasonable doubt?
No.
All right, 3.9, weighing the evidence. As to this appears to be standard, as to the factors for consideration 1 through 5 are always given. Do we need money or preferred treatment?
I don't believe so, Judge.
Mr. Levine?
I agree.
Pressure or threat?
I don't believe that's applicable here.
Mr. Levine?
I agree.
I will give inconsistent statements. Is that agreed?
Sure.
Mr. Levine, you agree?
Oh, yes, sir.
There's no felony or misdemeanor conviction, correct?
Correct.
And no reputation for truthfulness, correct?
Correct.
Do you agree, Mr. Levine?
I agree.
All right, so I'll renumber inconsistent statements as number 6. All right, the rest is standard, including expert witnesses. I will remove the defendant becoming a witness,
Yes, please.
and the rest appears appropriate. Agreed?
Yes.
Yes.
Do you want me to give 3.9A defendant not testifying?
Yes, please.
And am I giving 3.9B defendant statements?
Yes, please.
3.10 rules for deliberation appears to be standard. Is there any objection?
No objection.
Three point 1 cautionary instruction is standard. Any objection?
No objection.
3.12 verdict.
I would object if I thought it would do any good to, you don't have to be unanimous on the premeditation or the felony murder. But I don't think I have.
You're making a record preservation objection?
Yes, I am making a record for preservation purposes.
Do you wish to make any argument?
Just that I think that the unanimity requirement should apply to the different theories that the state has put forth as to first degree murder. I think that the instruction should be you're verdict must be unanimous either as to premeditation or unanimous as to felony murder.
Response, Mr. Lee.
No, Your Honor, I would ask that you instruct the jury on the standard jury instruction.
Law, as I understand, has not changed, and that under Florida law, they do not have to be unanimous as to the type of first degree murder, only that it be one or the other. I think this should go before the paragraph above it.
Yes, it should.
Do you agree, Mr. Logan, that the last paragraph should go above the second to last paragraph?
Wherever it's supposed to go, Your Honor.
Okay. All right, so that's where I'm going to put it, and you agree with that?
That's fine.
We'll talk about the verdict form in just a second. Single defendant, multiple counts, I'm taking out for information in the title. But that appears to be standard and includes the caveat for legally interlocking counts. Any objection?
No objection.
That takes us to legally interlocking counts. Now, if I remember correctly, the last paragraph is not standard, but it's something that has been used before. So this is sort of a special instruction, correct, Mr. William?
If I remember correctly, yes. I believe in these cases, maybe even Your Honor proposed it or gave the parties an option, and it seemed to make good sense and describe everything clearly and accurately. If the defense has any objection to something, I don't object to if they want something taken out that's beyond the standard.
So Ms. Thornhill, the first two paragraphs appear to be standard and accurate. That last paragraph reads, however, the alternative crime of first degree premeditated murder charged in count 1 is not linked to any other count in the indictment. A finding of guilty or not guilty as to count 2 does not affect your verdict as to the first degree premeditated murder charged in count 1.
I think that's an accurate statement of the law. I don't have an objection to it being read, even though it's not part of the standard instruction. It might actually help them figure things out if they actually notice that one is felony murder and one is premeditated murder.
So as to the rest of that instruction, any objections?
No.
All right. And that takes us to 3.13, submitting case to jury, which is standard. Is there any objection?
No objection.
And then an instructional discharge.
No objection.
All right. Are there any other, before we talk about the verdict form, any other standard or special instructions requested by the state?
No, Your Honor.
By the defense?
I'm sorry, hold on.
I just feel like the prosecutor's just a little strange acting. Is it just me? And I'm not trying to be mean or anything. I'm just.
Any other standard or special instructions requested?
He's hard to warm up to. He's just kind of,
Let's
I
take a
don't
look
know.
at the verdict form.
Verdict form. Dexter Jr. He's just a little different, which is not a bad thing. I mean, but
So as to count 1, the first choice is for first-degree murder as charged in the indictment. Second choice, the defendant is guilty of second-degree murder, a lesser included offense. And under that, the further findings, and then manslaughter, which does not have the further findings. So my thought is we separate the verdict form into guilt findings and then special findings separately, since it would become repetitive if after second-degree murder and manslaughter, they're the same section of special findings. Does that sound fair, Mr. Levine?
It does, Your Honor, and I would ask that you add the language under manslaughter that's there for second-degree murder, the special findings. It was I didn't put it on there as an oversight.
I think that also the finding as to actually killing, well, you've only proposed that they be asked about actually killing Catherine Griffith. You don't really need any of the attempted to kill or intended to kill language.
Yeah, by operation of the facts of this case, I'm okay with it just saying actually kill.
That's fine.
All right.
But I
Go ahead.
because he is a juvenile, and that's what those special findings pertain to, would you put it under after the guilt findings, then do that as a further finding? That's what
Yes,
you were
it would.
indicating. Okay.
So we would basically have count one and count two. It would be count one in order, first-degree murder, second-degree murder, manslaughter, not guilty. And then count two, kidnapping, false imprisonment, not guilty. Then special finding question one, if you found the defendant guilty of first-degree murder or second-degree murder, you must answer the following question. The defendant actually killed Kathy Griffith? Yes, no. And I explained when I'm going over the verdict form that those also have to be beyond a reasonable doubt and unanimous findings. And then, so that's special finding one. Special finding two, if you found the defendant guilty of second-degree murder or manslaughter, you must answer the following question. The defendant carried, displayed, etc. Yes or no?
That makes a lot of sense.
Mr. Levine?
Yes, sir.
All right. So I'm not going to pound through that here while you're sitting in front of me. I'll just correct it.
Thank you.
And email everything to you all this afternoon so you have it. And if you see any errors, it's invariably as I'm reading the instructions, I see one, but I would ask that you review them, and if you see any typos or other errors, to just alert them by email so they can be changed before they're printed tomorrow morning.
Yes, sir.
Is there anything else we need to take up this afternoon?
No,
I don't believe so.
All right. And I told the jury they'd probably be going to deliberate around lunch. Are you anticipating all-day arguments?
No, Your Honor, I think they will be deliberating by lunch.
I agree.
All right. Everybody enjoy the rest of your day. I'll see you at 8:30.
Thank you.
All right.
Well, at least you kids get the rest of the day off. Yeah, Name says he lost even before he sat down, though, through no fault of his own. Talking about the prosecutor. Christine, total Twilight Zone. I'm telling you, this is just... It's, for people like us that... Well, I say people like me, who I don't know all the legal references and whatnot. The fact that I've seen this is just blowing me away. I know enough to know that this is just... Something's not right. Okay, I promised you guys we would do this. So let's watch this body cam that I have here really quick before we leave.
Without my glasses, I don't know where they went. Hi. Hello. Who's who? I'm Deputy Jankowski.
Now body camera footage from the Charlotte County Sheriff's Office, that's where Collin lived with his mother, Charlotte County, Florida, is giving us a look at the domestic violence incident from November of 2023, where Collin was accused of beating up Kathy Griffith. He told deputies his side of the story when they arrived.
I got off the phone with Rentis. We sat down and we ate, and she started talking to me about how
a bunch of really bad shit. And then when I got up and was like, you can't just do that, and she was telling me to shut up, she hit me in the face, and then I reacted like this. She grabbed onto me, I hit her in the stomach, and then I'm a wrestler. It was just reactive. Grabbed her. She got to the ground. I grabbed the phone. I started recording, and then I left. Okay, that's it.
So she hit you in the face?
Yeah.
But we've been through this. You called Renters because you know you kind of messed up, right?
No, it's because I didn't know who else to call, and I knew that, and I wanted to make sure he knew first off.
Okay.
In the back of a cruiser, and then talked to his mom, Kathy.
It's Catherine A. Griffith, right? And then 9485.
Yes.
Okay. So I heard EMS is coming to check out your hand. Okay. Let me.
Right here, because he kicked me.
Okay. Hey, can I see your hand? Okay.
He kicked the phone out of my hand as I was trying to record it. I was on the ground.
Medics then checked out Kathy Griffith's injuries.
It hurts. I mean, you can see how swollen my knuckles are. It's okay. He literally stomped on my hand to get the phone out of my hand.
Let me see the inside of your hand. All right. Do you have any pain to your wrist at all, or is it just right here in the top of your hand?
No, it's
all of this.
Yeah, from here till about here.
Okay. When did that happen?
When he attacked me.
Was that like a couple minutes ago? An hour ago?
In the past 20, 30 minutes. And then he kicked me here. I have some redness.
Collin did not want to come back home.
Okay.
And I said, you don't have a choice. You have to go back home. And he said, no, I want foster care. And even the corporal was saying, foster care isn't going to be good for you. You don't have issues. You have to work on them. And so we agreed. I talked to him all the way. Oh, my car door's. Oh.
Collin has mental health issues, according to his grandma. He was in therapy and had a treatment plan, and there was some sort of intervention going on with law enforcement as well.
We talked all the way down, and I said, you have got to learn to get your anger under control. You want to be a Marine. People are going to get it. I'm retired from the service. I said, so am I. Very good. So I said, people are going to get in your face, and you're going to have to learn to deal with that. You just ignore it.
Right.
And I said, the other thing, too, is you don't ever hit anybody. You don't even touch somebody. And especially somebody as small as Kathy. That is just something that you cannot ever do. I said, that needs to be. He goes, no, but I said, there are no buts. That's all there is. So we got here. And Princess had agreed. She's going to lay the law down. You know, that she is the parent. She is doing what she thinks is best for him. That he's not going to have his cellular phone. He's not going to have access, because he's like talking to some person on online that we don't even know who this person is.
Okay.
And that she said, I don't want you ever calling me a psychopathic narcissist anymore. I said, and he goes, no, I didn't. He goes, no, I heard you say that. So, okay. He just, he had said that in the past. And she said, let me lay this out for you, because the only thing I think you really care about is money. So anytime there's an infraction, I'm going to take that from you, and it'll add up. So you have got to fly right, because otherwise, if not, and then he was doing something with his eyes. I think he wanted the phone, and that's all he was concerned about, was getting
his phone back.
His phone.
So was he upset about getting his phone back, or upset about not going on the cruise and going to get evaluated?
I think both.
Both? Okay.
Yeah.
And was she trying to record him with his own phone, or mom's?
Two phones were involved.
There was two phones.
So it was his and hers? Okay.
So she, just to kind of clarify, he's like, let's just do it. Got her phone to start recording. You said next thing you know, they're on the ground. Did you see how they got on the ground?
No.
Okay.
No. Because I was trying to call also.
Okay.
So, but I was very worried she was on the ground, and I went in between them. You've got to get your anger under control, okay? I'm saying prayers for you all the time, Collin, and I love you.
Mama, I think my anger's fine. It's just that when someone attacks me, I don't know.
What? I can't hear you. What?
No.
Do you think your anger's fine?
Yes, it's just when someone attacks me, that's how I act.
That didn't happen, though. I was there. I saw it. I saw you stand up. And I said, sit down, and you wouldn't. And you went after the phone. And the next thing I know, she's on the floor. And I'm trying to get in between Raw, and I'm trying to call Rennis.
No, she hit me. She grabbed onto me. I beat her, and then I got her to the ground, and then wrestling me, and then I ran.
I didn't see that, Collin. I really didn't. All I saw was you on the ground, or her on the ground, and you by her. And you guys fighting for the phone. So how did she get on the ground?
Just because I moved her on the ground. I wrestled her on the ground, and she grabbed onto me.
Why did you stand up? And why did you say?
So we're just trying to have a face-to-face conversation.
No, you didn't. You stood up and said, okay, let's do it. Let's do it. Yes, you did. I was there.
I was saying, Mom, I'm not a psychopath. I'm not this murderer. I'm just trying to peacefully leave or peacefully coexist and just figure something out. And she kept telling me to shut up and shut up. And when I wouldn't shut up, she hit me.
No, that's not what happened, Collin. That's not what happened. You never said you wanted to peacefully coexist.
I've been saying that.
You said that in the car, but not there with her.
The next day, deputies were back at the house with his mom after Collin had been released from jail.
All right. Yes, sir.
So what's going on, man?
Last night, me and my mom went to a physical altercation. I got arrested for domestic battery, but going in front of the judge today, I have a right to a public defender, and we'll see how that goes.
Okay. So how is the situation with you and mom right now? Have things calmed down? Are you guys able to get along? Where are we at?
No, sir. It's not good. She thinks that I beat the shit out of her. I don't. She thinks that I'm like psychotic, like literally psychopath, sociopath, something like that. I don't know exactly where she's at. She thinks I'm gonna kill her. I want to kill her, or that I want to beat the shit out of her.
Do you?
No, sir.
Okay.
I don't want to hurt anyone, let alone my mom, even despite this happening. But I'm not gonna take what I consider abuse when someone's attacking me. And
how is she attacking you? What
when she attacked me, when she threw a punch at me and grabbed on me, I grabbed on her back. I got her off of me. She hit the ground, and then I fled and called Rentis, and then he sent someone out.
You called who?
Rentis, Detective Rentis.
Okay.
The deputies then questioned Collin about statements he made at the jail.
Did you make any statements saying that you were going to kill your mom if you got in a car with her?
No, sir.
I'm trying to figure out why we would have a corporal at the jail that took you out, that dropped you off to your mom and telling us that you said, don't put me in the car with her, I'm going to kill her.
Yeah,
was that said?
I did not say I was going to kill her. I did not say kill. I don't know why he sent me back here. I asked him not to, but he said he didn't like my attitude and that I had to just work on it, and he sent me back here. But his words, not mine.
You can see how manipulative he is. And he literally, like him calling that other detective, once he had that other detective's phone number, because remember, guys, he'd already been through some process of this with his father's deal. And so now going into the deal with his mom, he probably learned a couple of things. And so now he can manipulate the system. Now, I can tell you right now that these cops are not falling for it. They can see right through it. You can tell they can see right through it. Otherwise, he would not have been arrested here. And that was my last point that I wanted to make to all of you guys, is that if I'm on the jury, I would be asking, if this were all true of what grandmother was saying, if mother was as crazy as everybody says she is, why is it that when law enforcement was there that they arrested Collin and they didn't bring DCF in or CPS in or whoever it was, and just gotten him removed from the home for his own safety? That's not what they did. Everything that law enforcement did was for the safety of the mother. I just hope that during deliberations, or I hope that after this is all said and done, we're going to be able to hear from the jurors, because I want to hear from the jurors as to what they saw in their eyes, because it's kind of hard to remember what they've seen and what they haven't. But if I was on the jury, I would be so mad that I was not allowed to hear the testimony from the Charlotte County behavioral people during the Baker's Act incidents because those are huge. That's huge, but they wouldn't allow that in. Prosecution tried to get it in and they wouldn't. So tomorrow's going to be interesting as far as closing arguments. Hopefully the prosecutor comes in with guns a-blazing. We know that the defense is going to. And we can go from there. So I'll see you guys at 8:30 Central or Standard, or no, 8:30 Eastern, 7:30 Central, same bat channel. You guys have a blessed evening. Go have fun the rest of your day. And I'll see you soon.